Just stay in
Welcome
Discord.
to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member.
Hey everybody, how are you doing? I am in the hospital with my son. We are going to be running this live. I will be in the background. What we're going to be doing is we are going to be looking at the old motions and following the old trial and getting everything passed so we know what's happening in the future, in the present and future with the Zachary Adams. So sit back, relax. June's going to take us on a ride through the previous motions and all the way back to the very beginning of this case. I want to thank everybody for your prayers. Please keep them coming. Okay, June. Okay, June, go ahead and start. Okay, June, go ahead and start. Okay, June, go ahead and start. Okay, June, go ahead and start.
Zach Adams, powered by Mr. Wilson, and then John Adams, powered by Mr. Maddox. The motions essentially sound in questioning whether the district attorney that is presently handling this case is duly qualified under our law. The motions are slightly different, but they sound in common grounds. This motion was filed very soon after I signed an order of appointment, and as a result, it has occasioned perhaps some delay in this case because until the court rules that she's properly qualified, I would have problems going forward with the case. Having said that, we've got the two defendants that are the subject of these motions in the courtroom. Counsel is over here at counsel table. If you wish to consult at any time, if you'll alert the court to that, I'll be glad to take that up. Thank you. Ms. Thompson, you filed your motion first, so I will be glad to hear you on this. Yes, sir.
So, in this matter, just for the record, to make the record clear, Matt Stowe, who was the elected district attorney, filed a motion to be recused at end of December 2014.
After a very public spat with the Tennessee Bureau of Investigation.
Yes, and matter of fact, last time we were in court, which I think was December the 17th, I had specifically asked Matt Stowe back in the hallway while we were here if he knew what this was papers because it was that morning that it all come out in the papers that he had allegedly ordered the TBI out of the 24th Judicial District. I specifically stood in the hallway and asked him what that was about, if he knew anything about that. He told me very clearly in front of my intern that he had no idea what that was about, that he had read it in the paper that morning just the same as I had, and that I'd have to ask the papers what that was about. He didn't know anything about it. And therefore, because of what he had represented to me in the hallway, I did not raise the issue in court that day. And then apparently there was a big feud somehow between Matt Stowe and the TBI. And then Matt Stowe at some point filed a motion to recuse himself. He did not specifically state in his motion any reason for his recusal. And then he filed an order, I think several days later. I was late on getting service on all of the materials, and he filed an order several days later. The court had signed the order before Matt Stowe's office had gotten me copies of the pleadings. And all that kind of happened also over the holidays, the New Year's holiday. So after I saw that this had happened, I filed a motion to vacate the appointment of Jennifer Nichols as District Attorney Pro Tem. And I cited the statute in this case. So it's my understanding, and I have had some discussion with Jennifer Nichols and Bill Witzel in this matter by telephone, and that there are two different ways in accordance with statute, and there's also a way outlined in the Tennessee Constitution as to what options are available if a district attorney cannot prosecute a case. And there's two different ways that this could happen. One is if the district attorney fails to appear and prosecute a case for some reason. I think the statute originally came about when they actually rode many, many miles to get somewhere to prosecute a case, and there could be all kinds of reasons the district attorney didn't show up in court. And that allowed a judge, it's in the Constitution plus in the statute, allowed a judge to appoint somebody to carry on regular court business. And then there's been a new, not necessarily new, but not original Constitution method by which a district attorney could turn to the district attorney's conference and request that
That's through Tennessee Code annotated 8-7-106.
Yes, 106B, which would allow them to turn to the district attorney's conference, and the district attorney's conference, they could make arrangements through multiple ways to have another district attorney substitute in to prosecute a case. But that involves everything being kept within the district attorney's conference, and it does not specifically involve the court in deciding who's going to prosecute the case or who's appointing somebody. And if it's done that way, the original district attorney may or may not participate in the prosecution of the case. And that is what had originally occurred because Jennifer Nichols was, in fact, working on the case before Matt Stowe had withdrawn. She was involved in the case sometime, I think, beginning in September or October, after Matt Stowe formally took office. And she, through the Memphis and Shelby County District Attorney's Office, was participating in the prosecution. And she, Matt Stowe, and I had had several telephone conferences along with other defense counsel and trying to work out some discovery issues. And that was performed through this 87106B, in which the district attorneys had made an agreement to borrow staff from another district attorney's office. So my objection in this case is specifically that Matt Stowe has recused himself, and there's two ways a district attorney can recuse themselves. One, they can say, I personally have a conflict, but the rest of my office can carry on going to be out of the case. And then there's another way that the district attorney's office can say, not only am I tainted and cannot prosecute this case, my entire office and even the support staff is also so tainted through whatever reason they had to be recused, maybe a conflict of interest, that nobody in the office can participate and all prosecution must come from a different agency. So in this case, once the district attorney moved to the court, and it's my argument from my motion that once Matt Stowe said that he was recusing himself, asked the court to recuse himself and completely be removed from the case, then the district attorney's office, his office, and the district attorney conference lost all of their standing. They lost their ability to then pick among themselves another attorney to trade out or replace Matt Stowe. But when they do that, the only way that they can do that is through the law, which is 87106A. And that is under the statute that matches the Constitution that says when a district attorney is unable to prosecute a case, then the court will appoint a district attorney to fill in for them. And one of the differences there is that when that happens, then it's the court who picks another attorney. But also when that happens, the attorney that comes in to replace that person then operates as a main district attorney. They are to receive full district attorney salary. They are to have all of the
Let me
privileges.
stop you just a second. Let me say I intentionally avoided anything in the selection process because I didn't want my fingerprint on picking someone where it might be that it demonstrated some type of bias. So I specifically had nothing to do other than to sign the order. I also mentioned on the telephone when we discussed that the original order appointing her, and I don't know why I still got it, normally I wouldn't have, but it contains a signature of Matt F. Stowe. I regretted that because I thought since he was recused that it should not bear his signature. But I think that at least implicitly, one might draw the inference that this is his granting of permission in addition to anything else that occurred in the process. So this will be filed as Exhibit 1. Since I mentioned it over the telephone, I think it's appropriate. All right, you can continue.
So my objection today then is how the district attorney's conference has gone about picking somebody and the manner in which they are bringing people in. So here's my objection. The court certainly, it would be appropriate for the court to pick Jennifer Nichols, and if the court decided wanted to pick Jennifer Nichols to be appointed, that would be appropriate. But in that case, she would come in and be the district attorney, she would come in as a main district attorney with full authority. She would not be under the supervision of Amy, I think it's Wyrick. She would not come in.
Wyrick's not here. Whitesell's here.
Sorry, she would not come in under her supervision, and she would not be using all of the Memphis, Shelby County District Attorney's Office supplies, support staff, things like that. Those things, part of the Memphis, Shelby County District Attorney's Office is specifically supported by taxpayer money from Memphis and Shelby County. And so she's still receiving the same salary she receives from the state through her assistant district attorney job that she's holding with Memphis. And I believe also they're planning on bringing in another district attorney from Memphis. So
Mr. LaPone, he's here.
Yes, okay. So my objection is the manner and method
Then
by.
I understand we also got someone from the state attorney general's office. Okay. I don't know that we challenged constitutionality or anything, but she's welcome to be here.
Yes. So my objection is the manner by which they did this. That once Matt Stowe withdrew and she came in as special prosecutor, she can't come in under the umbrella of the Memphis office. She needs to come in fresh as the district attorney that is with all full privileges, full salary, everything. But she needs to be fresh and she needs to not be working under the supervision of the Memphis district attorney. One of the reasons that this is very, very important is that should any of this come back, should we at some point have an appeal, should we at some point have a state post-conviction action, or if we should at some point have a federal habeas corpus action. One, it's going to be very important that we can clearly say who specifically was in charge, who was the person that is responsible, and which county is responsible. Also, if at some point in the future, Mr. Adams decides he's going to have some type of civil action that he takes against the state, perhaps for some kind of malicious prosecution, then he needs to know specifically which officials to hold responsible or to point to in that suit. And by having all of this muddled as the state has done, because once she's appointed, she's now still under the supervision of another office, and she's not specifically the prosecutor, then I believe it raises a lot of questions in the future as to what kind of proceedings are going to go forward. Now, I think it would be fine, but it is allowable, and there is case law that states that one, either the court could rescind its order recusing Matt Stowe. Matt Stowe could come back on the case, and then he could ask the district attorney's conference to provide assistance through another district attorney's office. That person could come in, and if he wants to recuse his whole office, then that person would statutorily be able to then use the resources of another office, work under another district attorney, having that district attorney supervising, and that would be very clear. The other thing that could happen is this court could appoint Jennifer Nichols to be the attorney pro temp, district attorney pro temp. But in that case, then she would be the head district attorney for this case, and she wouldn't be operating under the direction or supervision of any other attorney, and it would not be related to Memphis or Shelby County at all. Shelby County would be out of the case in the future should there be any other type of legislation or litigation that goes on in this matter. So that's what we're asking for today. The next thing that's going to be complicated, and I was instructed, it was my understanding from the district attorney, Jennifer Nichols and Bill Witzel, when we had our telephone conversation, was that we're not even addressing the issues regarding recusal. Because if something has happened, I don't know why Matt Stowe recused himself. It's my understanding that there was a huge disagreement between Matt Stowe and the TBI, and that he had been tape recording some of their conversations. He was trying to micromanage Memphis office, and they had a big blow up about that. And at some point, Memphis withdrew their support to assist unless he was completely out of the case. But even if that's so if there is a true recusal reason, that means that Matt Stowe has some type of issue that makes him ineligible to prosecute this case, such as he has a conflict of interest, he's a potential witness, then and everybody else in his office is off of it because of that. I don't know how that would not then, in the future, we'd have an issue as to Jennifer Nichols.
Do you draw any distinction between employer-employee and someone that's independent? In other words, the assistant district attorneys general work at the pleasure of Mr. Stowe. So it's employer-employee.
Well,
Ms. Nichols enjoys no such relationship.
well, at that time, she did. When she was earlier assisting in the matter, she came to be serving under Matt Stowe and as an assistant district attorney in this prosecution of this case. But she was still reporting, as far as the Zach Adams case goes, she was reporting to Matt Stowe. He was supervising her, they were having conversations. So if there's a conflict of interest, if Matt Stowe learned some secret or some information that meant he had an attorney conflict and was unable to prosecute the case, I want in the future then to have a full hearing on what his conflict was, to know why then Jennifer Nichols would not also be under that same umbrella. It is possible for a district attorney themselves to remove themselves from the case, such as, let's say they had a previous personal relationship with a defendant. They said, I can't prosecute this defendant, but we're going to build this, I think they used to call it a Chinese wall. I'm not sure if that's
Firewall, whatever.
a firewall. They would build this firewall between them. Other people in the office can still prosecute the case. And I did a lot of research. There's plenty of cases that show that. But for whatever reason, if he's had to completely get out of the case and it's a legitimate reason, not just a
Let me
political
say,
reason.
this is a rural district. Firewalls are very difficult to erect, okay?
I recognize
It's small,
that.
intimate staff.
But if the mere reason that Matt Stowe is out of the case is because the TBI said, we're so mad at you, we're not going to work with you anymore, then I don't think that's a legitimate reason when he's elected by the people to prosecute cases for him to be out of it. And then why would that take the rest of his office out of it, such as the entire Memphis office, and it's their support staff, their copy machines that has to be prosecuting this case. I object to that.
Let me also say this. I'm trying a case in this county less than a month. It's got an attorney general pro tem. When I have an officer of the court tell me that I'm moving to be recused, frequently I won't delve into a whole lot, but as an officer of the court, I will accept that conflict position.
Yes.
So I've got a attorney general pro tem from the Waverly district that's handling, it's a fairly high profile case. We tried next month.
Yes.
But the entire staff came off of that as well.
So, but my question is, in this case, I believe that I have an ethical duty to my client to investigate what that conflict was and to have it on the record as to whether or not that would apply to Jennifer Nichols.
Mr. Maddox, you got anything to add?
Yes, Your Honor.
Doesn't
Morning, Your Honor, by the way.
surprise me, okay?
May it please the court. Your Honor, my argument, I'll try not to be duplicative of Ms. Thompson's argument. My argument is similar in ways, but it's also different in ways. In this case, as my motion and memorandum states, the office of the District Attorney General is a constitutional office. It's one that's created by the Constitution of the State of Tennessee, as well as your position of the circuit judgeship, Your Honor. It's also a constitutional office. And because it's a constitutional office, there are parameters that are in the Constitution that provide for the substitution of a duly elected District Attorney General in only two circumstances. And those two circumstances are when the District Attorney General fails to attend or fails to prosecute a case. That's it. That's the only authority a court, a circuit court or any other court in this state has to order the appointment of another District Attorney General. And that, I believe, is where an error has been created in this case so far, in that I don't think this court had the authority to appoint Jennifer Nichols or any other District Attorney General because General Matt Stowe did not fail to attend or fail to prosecute this case, as evident throughout this entire matter, his public appearances and his appearances in court. So therefore, I do not believe that the order that this court is valid, and I think it's void ab initio. Uh, However, that doesn't end the argument in this case because, as Ms. Thompson has stated, there is statutory authority, and that statutory authority is based upon the constitutional authority of that office. That statute is 8-7-106 of the Tennessee Code Annotated, which has been previously listed. Subsection A of that statute mirrors almost identically to the constitutional aspect that I just spoke about, saying that this court can order another district attorney general in those two situations. However, it goes on further by the state legislature in providing another means for a duly elected district attorney general to transfer authority that that person may have to someone else, or transfer certain authority. I believe under subsection B, the original district attorney general, since it's a constitutional office, always retains the power of that office. They never vacate that under subsection B. So therefore, Matt Stowe, in my opinion, is still on this case, even though he has said and he has wanted to recuse himself. He can transfer that under subsection B. And that's what I believe the state has admitted in their response, that in this case, then it would have to occur under subsection B1 of that statute. They don't mention anything about the constitutional aspects and whether or not the authority for this court to order that transfer is under the constitutional or subsection A. So therefore, the state, I believe, understands, and there's a problem with this. And they are stating in their response that it's under subsection B1. But even so, that still doesn't end my argument. My argument in this case is that section also provides that a district attorney general or an assistant can be lent to another district attorney general for the purposes of prosecuting a case. It can be from the attorney general's office, who's represented here, which I assume they will come in and prosecute certain cases. It can be from another district attorney general's office, just as you mentioned that the Humphreys County district attorney general is bringing someone in on that case. And in that case, I think it's very clear, then you pointed out, Judge, that General Stowe's office has recused everyone from that case. So therefore, there's no one else that is in the 24th Judicial District Attorney General's office that's prosecuting that case. And I think it's very important in this case for that to be pointed out. And the reason for that is that Jennifer Nichols was also appointed or was transferred pursuant to subsection B to General Matt Stowe's office prior to anything happening that would cause a recusal. So therefore, she was essentially part of his office at that time because his office was ill-experienced in the prosecution of homicide cases and really prosecution of criminal cases at that time in general. So he brought in a special prosecutor, I guess you can say, who is experienced in prosecuting this type of case to help him in this matter. And that was done shortly after he was elected district attorney general, and way before the brouhaha that occurred in December, which I'll get to in just a few moments. So therefore, she was on this case with him, assisting him, working side by side for a number of, I don't know exactly because I don't know exactly when she was actually brought on, but for a period of time prior to anything happening. So therefore, she was essentially an employee, but I know you were wanting to get to the semantics of that and technically she may not be an employee because she was still being paid by the Shelby County DA's office. But Your Honor, there's such things called agency. And that's what was created here. That she was an agent of General Stowe's office. And therefore, since she was an agent and the agency relationship was created, then anything that happened in that office can also be attributed to her. So if General Stowe later said there was something that came up and to recuse himself, then since she is an agent of General Stowe by virtue of that statute, then she necessarily has to recuse herself too, because he recused the entire office, not just him, not just one particular DA or assistant DA, but his entire office, just like you said they did in this other case. So therefore, because she was an agent prior to this happening, she has to be recused also. And that's the main point that I'm trying to get at. And by admitting that she was brought on under that particular section of the statute and not under any constitutional provision, then the court has to look at that. And we have to look at the basis for the recusal itself. Your Honor, I believe that the basis of the recusal arose out of certain meetings that took place on or about December the 13th of 2014, in which Mark Gwynn and Jeff Puckett were present in a meeting, as well as General Amy Wyrick, General Gary Brown, Miss Jennifer Nichols was present, Wally Kirby was present, General Stowe was present, as well as one of his assistants. And at that meeting, General Stowe made a comment that the TBI had compromised the case by proceeding so slowly, and they were leaking information and possibly covering up evidence. And he said he did not trust the TBI and didn't want them in the case anymore. Furthermore, he said he didn't trust anybody in the room at that meeting. Now, this is all secondhand to me. I don't know whether or not that's it, but that came from the executive director of the District Attorney General's conference. So therefore, there's a serious issue about the recusal of Matt Stowe. And therefore, there will be a serious issue about the recusal of Jennifer Nichols and whether or not she should proceed on in this case. I'm not saying anything that did or didn't happen because I wasn't present. I would like to have General Stowe here on the witness stand to be able to testify to that. I'd like to have Wally Kirby here to testify, or Amy Wyrick, or any of the other people there to determine what was the exact basis of the recusal of Matt Stowe. His motion didn't say anything on that, now, but I think it's important on this. Additionally, Your Honor, the state of Tennessee responded in their, or in their response, stated that there were certain protocols that had to be, or should be followed. And they provided a copy of that in their response, which I assume that the court has, which is stated the Tennessee District Attorney General Pro Tem Protocol, which that's correct. And it says as updated December the 1st, 2014. First of all,
Mr. Maddox, you know me well enough to know I've read everything.
certainly, but I didn't know what was submitted to you and what was submitted to me.
Well, I've
So
asked
that's
everybody
why-
to send me courtesy copies when they file them, because my office is about 40 miles away from here.
As well, I'm aware of that.
You're aware of that.
But this has no legal effect. There is no basis in law for this to have any effect. So therefore, whatever protocol they want to do, that's only within the District Attorney General's conference themselves. And therefore, it has no basis in statutory or constitutional basis. But what I'm wanting to bring up here is, first of all, the protocol says that they are to submit a District Attorney General pro tem request, which is supposed to give the reason for a DA qualification. Well, the motion or the form that I have is in complete blank. There's nothing about a form, and I've never seen a form that has ever been submitted by Matt Stowe. If we had that form, then that may clear up some things. But I don't believe that form probably exists, Your Honor. And if it does, I certainly haven't seen it. And if the DA's conference or the state had it, I'm sure they probably would have attached it in response to my motion. So therefore, they didn't follow that protocol. But more importantly, Your Honor, on the first page of that, it says the definition of a conflict is set forth in the National Prosecution Standards as published by the National District Attorney Association. The Tennessee Board of Professional Responsibility may be more restrictive in some areas, and if so, the decisions and or opinions of the board shall control. I cited in my motion, Your Honor, Rule 1.10, 1.10 of the Tennessee Rules of Professional Responsibility. That rule specifically prohibits any attorney that was in an office that has then a conflict of interest has arisen or a reason for recusal has to be removed from a case. They cannot participate. And since Jennifer Nichols was a member of that office prior to this recusal situation, then she has to remove herself pursuant to Rule 1.10 of the Tennessee Board or Tennessee Rules of Professional Conduct, or she is has an ethical violation or is committing an ethical violation, and she would be subject to discipline by the Board of Professional Responsibility. So that's something else then that we must consider in this case. And I think it's a very serious issue on this. Rules are rules, as they say, Your Honor, and we have to follow those rules. General Warwick had to consent for Jennifer Nichols to work for Matt Stowe pursuant to that statute. So therefore, I'm not so sure that her whole office is not conflicted out for the same argument that I've made for Jennifer Nichols. And other than the agency argument I've already made, I believe that's all I have at this time, Your Honor.
Your Honor, before we get that, Mr. Maddox was reading from a document in his possession. I haven't seen that, but for the record, could we just put on the record what that was he was reading from? What were you reading from?
Which document?
Tennessee District Attorney General pro tem protocol.
No, he was reading from some, looked like emails. Are these
Oh, I
emails?
have no idea what he's reading.
No, I'll be happy to tell the court what that was. And the reason I don't have that is because that's not been provided to me through any discovery by the state of Tennessee. What I have are emails between Director Mark Gwynn, Wally Kirby, who was the executive director of the Tennessee Attorney General's Conference at that time, and Amy Wyrick, who is the District Attorney General for Shelby County, where they were memorializing the meeting that caused all of the problems in this case. And this was obtained by one of the Nashville news stations, which they were kind enough to provide a copy to me, but they obtained it through the Freedom of Information Act.
Will you make her a copy?
I've given her a copy.
Oh, okay.
Ron, could you follow this with the record, just so that it's clear as to what he was
He
reading?
did too. Could we see it?
Honor, the copy that I have has been redacted by the state, so therefore there's certain information that has been blacked out, which I do not know what that is. Your Honor, whether reviewing that too, I specifically want to state on the record that I'm not claiming that Jennifer Nichols has really done anything wrong. I don't know. I'm not saying that she has, and whether or not Matt Stowe's done anything wrong, that's yet to be determined. But whether or not what Matt Stowe did it can be attributed to her would cause a problem with her. That's the issue that I'm saying. And I want to make clear that I'm not making any accusations against Ms. Nichols at this time, or will I ever that I know of. But I just want to make clear and state that on the record. Once again, while he's reading that, it's my understanding that Wally Kirby, who was the executive director, well, I think he was either retired or resigned. I don't know what the proper term is, but I think he would be appropriate. That's correct. But he would be subject, I think, to discipline.
His retirement or resignation was results of another situation that was fairly public as well as this.
My only objection would be to the level, Your Honor. I don't find it being filed as an exhibit.
Well, it's pretty broad hearsay too.
Yes.
It'd be filed as exhibit two. All right, who wants to respond in the statement?
Hey, please support. My name's Bill Whitesell, and I'm the interim acting director of the Tennessee District.
Spell your last name.
Yes, Whiteselo. And I'm the interim acting director for the Tennessee District Attorney General's Conference. And I have filed a response to the motion filed on behalf of Zachary Adams That response was filed, I believe, February the 19th of 2015 or thereabouts. And it sets out our position. Your Honor, we've heard a lot, and I know the court's familiar with the history of the procedural history in this case, so I won't belabor that. But we've heard a lot about a conflict, but we have no proof that there was a conflict, or if there is, what it is. And the fact of the matter is, if another district attorney, for whatever reason, doesn't want to be involved in the case, and with his consent, ask someone to come in, and they agree to do that, then that's the end of it, under what we
I
believe.
would assume this is done on a very regular basis.
Yes, sir. Very regular.
Because
Maybe because I worked with a police department they weren't happy with. And so there can be any number of reasons. And what we have before the court today is a lot of speculation. And that was my objection to the document. As the court notes, it's full of hearsay. I'm not sure it's relevant, even if it was factual, to whether or not there can be an appropriate appointment of a pro tem district attorney in this case. I think the court studied it, you've researched it, you know the posture of all the parties, and frankly, I don't think there's any reason to stand up and argue any further. Thank you. I would say one other thing. For the record, and I would like for Ms. Nichols to state on the record whether she does have a conflict that would preclude her from acting as the district attorney pro tem in this case.
Your Honor, may I suggest to the court that we put Ms. Nichols on the witness stand and let her testify as to the validity of the information that's contained in the email since she was present.
For the court, if she tells me she has no conflict, that will end the inquiry for now. The same as if you told me as an officer.
That's true, Your Honor, but their argument response is that there's no proof of recusal. She has that proof, Your Honor, and I think that we need to hear from her.
Good morning, Your Honor. As an officer of the court, I state unequivocally that I do not have a conflict, have never.
It occurs to me that you should feel flattered.
I do a little bit.
As hard as they are trying to have you removed.
They are working.
And quite frankly, knowing the extreme burden this is going to put on you professionally for a period of time, as well as anyone else involved in this case, I think it probably demonstrates a lot of professionalism that you didn't say, okay.
We thought about it. But as an officer of the court, there is no conflict. There wasn't then, there's not now, and I wouldn't be here standing here before you saying that there wasn't one if there was. So, and I appreciate the court's acknowledgement that my word as an officer of the court is good enough, that I don't need to be placed under oath to make that statement.
Same thing on any of these attorneys.
Y'all, this is getting spicy.
All right, anything further? All right. The court makes the following findings, that the district attorney general pro tem, that there are no irregularities in the appointment. It is a valid appointment pursuant to Tennessee Code annotated 8-7-106B1. If I were to lend credence to any of the arguments that have been proposed by the defense attorneys in this case, certainly I would be putting form over substance. And in looking at this, there are no irregularities. The appointment is valid. Anything further?
Nothing further, except for, Your Honor, I have, as the appointed district attorney in this case, requested the assistance of Ray LaPone and submitted for Your Honor's approval his appointment.
I think it's been entered, and if I were to disqualify you, I would disqualify him. But the fact that you're not disqualified, if that hadn't been, if I hadn't signed the order and been entered, it will be. Okay? Thank you, Your Honor. All right, anything further?
Your Honor.
I intend to file a court order confirming the court's ruling here shortly.
permission for an interlocutory appeal.
Rule 9, permission for interlocutory appeal hereby overruled by the court.
Thank you.
Judge. Yes.
There were other motions you were going to say it. You want to go ahead and say it?
Yeah, thank you, because I gave you a date. My next date on this, and it will be as to motions on any of the three defendants, will be June 3rd at 9 o'clock a.m. I would ask that prior to that the attorneys advise the court specifically what you want heard on that day. I'll be on vacation the week before, but, I was trying to first degree murder 2 days before that, so get it to me as soon as you can, okay? All right, anything else to come before the court?
John, was the court prepared to order on this?
Yeah. Well, somebody will. Ms. Bird,
Somebody was
I
going to.
said somebody will prepare the order.
I just wanted to make sure it wasn't me. That's
No,
something.
we get you a certificate of service, okay?
Thank you.
All right. All other matters are reserved.
Your Honor, I do have another order that needs the court's attention, but I can do that outside.
Different matter?
Yes, Your Honor.
Okay, all right. All right. All right.
That was an abrupt all rise.
Indictment. I've been discussing with, this is a new indictment, but we will be taking up all. Okay, good morning, ladies and gentlemen. I didn't bring the new indictment with me. I had it back there. This, here it is. I just used this. Okay, we're here today on the case State of Tennessee versus Zachary Adams, Jason Autry, John Dylan Adams, number 15 CR 30. This is a new indictment, but we will be taking up all matters that touch on these three defendants, from the old indictments and anything that counsel wants to bring up concerning the new indictment. I've been discussing with the attorneys essentially the protocol that we will be following. I was disturbed recently when Monday a week ago, a news report was released by it was obvious that material had been furnished to that television station that essentially is not in the public domain. They read apparently from information that is
Oh, crap.
file under seal, and I was a little, I was upset by that, because if an attorney had leaked that information to the press, I would deem it very, very unprofessional. I have some problems with the news media that gets material that has, quote, been leaked to them and then releases it and sensationalizes it. I told the press early on that I could be their best friend or I could be their worst. I've been on the bench over a quarter of a century. I have sealed very few files, usually for minors and things that are required to be sealed by statute. I have never issued a gag order. But I will say that if things continue to be leaked and sensationalized, the court might be put in that position. I would hope that the news media will be professional in what they release, because they could be jeopardizing being placed under gag order in this case. I don't want to do that. I think the public has a right to know. But things that are not public, so I think that's probably enough said about that. And if I were a member of the media, I think I would talk with my colleagues about jeopardizing my further access. We will be taking each individual forward. Or 10, whatever. We will be taking each individual defendant up. First order of business will be arraignment, and then I will take any matters that counsel wishes to take up touching that case. There's been a development that has occurred this morning that I think significantly impacts this case and will affect the speed at which we can travel in getting this case ready to trial. I understand that the state this morning filed notice of aggravating circumstances and intent to seek the death penalty as to each of the 3 defendants. Is that correct?
It is, Your Honor.
All right. As a result of that, it will become necessary for the court to appoint additional counsel for at least have individual counsel, and the court will be in the process of appointing someone that is death penalty qualified to assist on the case of Zachary Adams, Ms. Thompson, and John Dylan Adams, Mr. Maddox. So court will hopefully get someone. You've suggested someone that you think you can work with well. I'll be checking with Mr. Matty. I'd rather have someone that is willing to act on this case as opposed to the court appointing someone that would join with reluctance. So we will see if we can take care of that. That's essentially what I discussed in that background. Is what we've covered up to now. Let's go ahead and bring Zachary Adams in. Let's bring him to the podium. You are Zachary Adams.
Yes, sir.
Mr. Adams, in case 15 CR 30, there's been a new indictment that has been issued. This essentially is a superseding document. It includes primarily the charges that you were earlier charged with under a different indictment. There might be some additional charges as well, but most of these charges were on the other indictment, but you are now indicted with your 2 co-defendants in one indictment. In count 1 of the indictment, you have been indicted with the offense of first-degree murder. It is essentially, you're charged with unlawfully killing Holly Bobo in the perpetration or the attempt to perpetrate kidnapping. It's what legally is known as felony murder. Do you understand what you're charged with?
Yes, sir.
You understand the nature of those charges?
Yes, sir.
Ms. Thompson, do you waive the reading of that indictment?
Yes, Your Honor.
All right, we'll go to count 2. You are charged along with the co-defendants on that, having committed the offense of especially aggravated kidnapping in violation of 13-305. Do you understand what you have been charged with?
Yes, sir.
Do you understand the nature of that charge?
Yes, sir.
Do you waive the formal reading of that? Ms. Thompson?
Yes, Your Honor.
All right, Ms. Thompson?
Yes, Your Honor.
All right. As to the 3rd count, you're charged along with two co-defendants with having committed the offense of especially aggravated kidnapping in violation of 39-13-305. Do you understand what you have been charged and the nature of that charge?
Yes, sir.
Do you waive the formal reading of that indictment?
Yes, Your Honor.
Count 4, you are charged along with co-defendants with having committed the offense degree murder. It's a felony murder once again that you did unlawfully and with the intent to commit rape, kill Holly Bobo in the perpetration or the attempt to perpetrate rape, thereby committing the offense of first degree murder in violation of 39-13-202. Do you understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, count 5, you're charged with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand count?
Yes, sir.
Do you waive the formal reading?
Yes, Your Honor.
All right, count 6, you're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you're charged with on that count?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
To that, with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
Count 8, you're charged with having committed the offense of murder in the first degree, premeditated killing of Holly Bobo in violation of Tennessee Code Annotated 39-13-202. Do you understand what you've been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, that completes the arraignment process.
And he enters the plea of not guilty.
Yeah, let the record so reflect a plea of not guilty is entered. It's my intent to attempt to design at some point a scheduling order. In speaking with the attorneys, discovery will be an ongoing process. However, state's attorneys have indicated that they're ready to turn over all discovery within 30 days. And I've given them some extra latitude. They said they've actually got it ready. It could be done within a week. I will consider that to be the attorney's work product when they receive it. I expect you to share it with your defendant in consultation, but I don't know that outside sources should necessarily benefit from your discovery, okay?
Yes, Your Honor.
All right, what other matters do we want to touch on Mr. Zachary Adams?
I would like to say for the record, just in terms of the report that was on Channel 5 last week, while I have been provided with the photographs that they referred to in the report, I have not been provided with the affidavit to the best of my knowledge, and I've been through that discovery, and I've had multiple people go through that discovery. I've not been provided with the affidavit that they referred to, and I have not been provided with the TBI lab report that confirmed that the blood was Holly Bobo's. So I don't even have that information. I would like it, and hopefully I will get it soon, but I don't believe I have that information.
They will get you the discovery. She said it is indexed. It's indexed. She will furnish a copy, the same copy to each attorney. In that material are co-defendant statements, if there are any. There's also jinx material, which technically they're not required to provide until after that person testifies, but they might very well be aware of my history. I mean, it's possible so as to not delay a trial.
Yes.
And on top of that, Your Honor, I had an opportunity to speak with Ms. Thompson this morning and have made ourselves available, and that we've agreed, I've offered to, once the discovery is given, to meet with her, answer any questions she has about, what we were providing, point her in a particular direction if she has questions.
I think open discovery I think it facilitates the case moving and is beneficial for all parties, both the state and the defendant.
When she gets her co-counsel in line, it's probably, that would be the time to do it, but the offer remains on the table.
Well, as I said, one of my primary objectives is to preserve the defendant's right to a fair trial as well as the state's right to a fair trial. And I think open discovery will actually aid all parties concerned.
And there was an objection that I had expressed at prior hearings, and the state assures me that open discovery doesn't mean just come and look and see what we have, but they will file a record with the court so we can be clear as to what I've been provided.
We're going to file
it directly with me.
Going to file a duplicate copy now, I know, directly with Your Honor.
That way, as we run into discovery disputes, we'll know where we're going, okay?
At this point, Your Honor, in light of the fact that the state has just filed this notice of aggravating circumstances on the new charges, we had several motions that were before the court, but I don't believe that now is the proper time to have hearing on those. We'd like to continue those matters until we have an opportunity to.
At some point, we'll be proceeding totally under the new indictment, and I would assume the old ones because everything's covered in the new one. But we want to preserve your right to present those motions if you wish or desire.
Can we say that those motions, any motion that I've filed in the other case will automatically transfer to the new case? The discovery?
It is fine with us. That's the only reason that I've delayed this, was because I frankly didn't want the defense.
Let's not gnaw across yet.
Okay, I don't need to file a new motion for discovery, and I had a motion regarding Brady material. I don't need to refile those duplicate motions in this.
Unless you find deficiencies in the discovery, at which point you can file anything to bring the matters to the court's attention that you feel are appropriate.
But
then the circumstances with filing the notice have changed dramatically.
Yes.
And I had wanted to find out how long you folks felt Oceans. We've got a whole new situation. So I'm not going to be able to move at breakneck speed as I had hoped. I think in fairness to all parties, when you're talking about the ultimate punishment, then there's a heightened due process. And I want the attorneys to have an adequate time to file their motions. But I'm going to suggest it in 180 days. So let's start looking at that framework, okay?
Yes.
And that will be as to each defendant.
Yes.
Okay? And we will try to have new counsel on board probably by the end of this week. Okay?
Yes.
Matter of fact, you might notify that person and make sure, because this is going to be very burdensome. You already know that.
He knows.
Okay.
He's been involved. He's aware of the nature of the case. He's
Okay.
actually met Mr. Adams, and he's prepared.
Okay. Is there anything you don't understand at this point, Mr. Adams?
No, sir.
All right. Let's dismiss Mr. Zachary Adams.
Yes.
Bring in Jason Autry. Just at the podium there. You are Jason Autry. Yes, sir. Mr. Autry, we're here today to arraign you on a new indictment. This is essentially something that will take place of the old indictment. There might be additional charges on this that were not contained in the old indictment, but you have been indicted along with Zachary Adams and John Dylan Adams in one single charging instrument. We're here today to arraign you on these charges and then take up any other matters that you folks feel are appropriate. You are charged in case 15 CR 30. In the first count, you're charged with what is known as felony murder. It charges you with unlawfully and with the intent to commit kidnapping that you killed Holly Bobo in the perpetration or the attempt to perpetrate kidnapping. Therefore, committing the offense of first-degree murder in violation of TCA 3913-202. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Do you waive formal reading of the indictment?
We do waive formal reading. I would qualify Mr. Autry's answer as to the nature and cause of the accusation. We have had a continuing problem in this case with that, and we don't want to waive any objections.
You're not waiving anything today, okay?
Very well.
All right. Count number 2, you're charged with having committed the offense of especially aggravated kidnapping of Holly Bobo in violation of TCA 39-13-305. Do you understand what you've been charged with?
Yes, sir.
Same situation, he understands the nature to the extent not waiving anything.
Right. We understand what statutes are involved.
All right. You waive the formal
We
reading.
waive the reading.
All right. Count number 3. You have been charged with having committed the offense of especially aggravated kidnapping of Holly Bobo in violation of TCA 39-13-305. Do you understand what you've been charged with?
Yes, sir.
Same situation, waive the formal reading.
Yes, Your Honor.
Count number 4, you're charged with having committed the offense of felony first-degree murder in the perpetration or attempt to perpetrate rape in violation of Tennessee Code Annotated 39-13-202. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count 5, you've been charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count number 6, you're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count 7, you're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you've been charged with?
Yes, sir.
Waive formal reading of the indictment.
Yes, Your Honor.
Pleas of not guilty will be entered on, well, I've got the 8th count as well. You've been charged with having committed the offense of premeditated murder in the first degree in violation of TCA 39-13-202. Do you understand what you've been charged with?
Yes, sir.
Waive formal reading, Mr. Ferguson.
Yes, Your Honor.
As to the indictment, counts of, or pleas of not guilty will be entered as all 8 counts of the indictment. Other
Your Honor.
matters that you wish to take up today, or are you in the same situation that Ms. Thompson was?
Your Honor, we would ask that Mr. Autry be determined to be indigent for purposes of support services, expert assistance. I realize he'll need to fill out an affidavit.
Can you get that affidavit and get to the court, and I will, I think there's very little question. You don't have any financial resources.
Absolutely not.
I'm going to make a preliminary determination of indigency for purposes of getting support services, mitigation specialist, whatever are deemed necessary in his proper defense.
Very well.
If you'll get me an affidavit to support that.
Certainly
Okay.
will. In regard to Mr. Zachary Adams, there was discussion of open file discovery. Do we have an on-the-record representation that open file discovery will be provided as?
I don't know that we said open file. What we did say, you'll be furnished the same discovery of each defendant. State will be under a continuing duty to provide any additional discovery.
Very well.
Is that correct?
Yes, sir.
I think she's giving you everything she's got.
Very well.
And you've already essentially, under 2 DAs ago, had essentially an electronic dump that I understand it's just unbelievable the amount of material in that that stretches the human imagination, but she will have this in form indexed, and I will have a copy so that when we have any discovery disputes, we'll know where we can go.
Yes, we were furnished 2 external hard drives that the defense had provided to the state. There was some difficulty in the organization of it, but I'm pleased to hear that this will be indexed.
We're indexing it, we're not organizing it perhaps the way that defense counsel wishes that we would. They'll have an index. They're still gonna have to work. There's no way to make this small. Your Honor made reference to the voluminous amount. It's over 4 terabytes. I've been told that's a quarter of the size of the Library of Congress. Can't make it small, but they're gonna have an index.
I understand.
The haystack's still there. They're going to give you some needles.
I
Okay?
understand.
You want to hold your other matters in reserve?
Yes, and Your Honor, as to indictment number, the previous indictment, number 2014 CR 20, we had motions pending that request dismissal with prejudice, and we will accordingly object to any nollie prosequi there.
We're keeping those files
Yes.
open until everything's done, and then there'll be no process.
Yes, and I understand, I received one motion from the state, one filing from the state, it's the state's response to defend this motion for bill of particulars. I understand there's an additional 83-page or so pleading or filing that I've not yet
There's some
received,
cases
so-
attached and some other matters.
So if we can hold those off until later, I
And
would
then
advise.
I want you to get your discovery before we address the bill of particular issue. The state is saying we will give you complete discovery such that we feel that it will obviate the need for a bill of particulars. The court will cross that at a later time.
I understand, and Your Honor, I do.
And then I guess we ought to say, Mr. Flanagan, who's also co-counsel, he received the court's permission to be away today.
Yes.
He's apparently got a vacation scheduled,
That's what I understand.
and I think it's good that attorneys periodically take vacations.
Very well.
Ms. McGinley had me on vacation last week with grandkids. So,
Very well.
all right, anything else on this?
I would apprise the court that I do anticipate fairly promptly filing some dispositive motions regarding the new indictment. And if we can, since that would moot out the case, if we could take those up pretty promptly.
How soon?
I can file them by the end of next week, and they can be for hearing anytime afterwards.
Of course, the state will need to respond, so. And I don't know what motions he's talking about.
Well, I can apprise that.
How about July 29? That's about a month and a half.
Very well.
I try to keep Wednesdays available for this case because a lot of the courthouse offices are closed, and with the enhanced security and the things, I try to do that. Let's see if we can.
Your Honor, was that a date for a hearing on that motion? Is that what you just announced?
It would not be, well, might be an evidentiary hearing, but I don't know yet whether it will require evidentiary hearing. Morning or afternoon, Your
I
Honor.
guess I'm asking if we can, since we don't know what motion to refer to, can we at least get a copy of it and see whether or not it requires?
Let's tentatively set it for July 29, and then is that a problem?
Okay.
I'm turning on my calendar.
Morning or afternoon, Your Honor.
Morning.
Morning. And I will
That
say,
way, I've got all day if it takes it.
They will. And I can state that the grounds for dismissal I anticipate will be Rule 8A of the Rules of Criminal Procedure plus the due process doctrine of prosecutorial vindictiveness. That's what I anticipate this time.
I can take up, if we just got you, that's fine. If there's something touching on the other people, then I'll make that date available as well.
Okay, I'm not available that day. That's why I'm just asking if this is for everyone or just this defendant.
Well,
I can do it the 22nd, a week earlier, or I would have to go into the last week of August.
22nd works for me, Your Honor.
I can do it the last week of August, Your Honor. I'm not available the 22nd.
26th of August, tentatively.
I'm available, Mr. McCollum's checking. Okay, it's good for the state.
If they haven't changed, and I think they have changed, used to the court system in Shelby County closed down during August. Maybe it's civil. I think it harkens back to the days before air conditioners. And they just haven't changed that rule.
We both have trials in August, it's definitely not.
Okay. So we'll hold that date. And then if problems arise, I can take up things by telephone conference.
Do it.
Okay? I mean, just scheduling things. I don't want to hear anything that is material, just scheduling problems.
Okay.
All right? All right, anything else on him today?
I would like an opportunity to confer with Mr. Autry before he's taken back. I'd like to observe Mr. Dylan Adams' arraignment, but if I can make sure I ask him to find.
All right, can we hold him? Where's my TDOC? Yes.
Thank you, Your Honor.
Your Honor, there are people in the courtroom that were subpoenaed by Mr. Ferguson, that if he's not going to go forward, I'd ask that they be allowed to leave.
Oh, certainly. Yes.
All right, anyone that's subpoenaed on behalf of State of Tennessee versus Jason Autry, you're hereby released.
So long as they're subject to being present for any future motion hearing with regard to. Thank you.
All right, Mr. Autry, you got any questions?
No, sir.
All right, thank you, sir. All right, we got a place where he can meet after our hearing.
Yes, sir. Yes, we do.
Okay, so he can exit there and then you'll make him available.
Yes, sir.
All right, thank you, Sheriff.
Thank you.
All right, let's bring in John Dylan Adams.
Your Honor, I do have an affidavit prepared, but he's not yet signed that I will be submitting that to the court.
I've already found him to be indigent.
That's
so
correct, Your Honor.
I don't know that it's necessary, but you're appointed on this. I'm going to execute it today's date, but it'll be not pro tunc.
Thank you, Your Honor.
All right, you are John Dylan Adams.
Yes, sir.
Mr. Adams, in case 15 CR 30, a new indictment has been returned by the Decatur County Grand Jury. It contains earlier charges as well as additional charges, and you have been indicted along with two co-defendants, Zachary Adams and Jason Autry. The first count of that indictment, you are charged with having committed the offense of felony murder, alleging that you did unlawfully and with the intent to commit kidnapping, kill Holly Bobo in the perpetration or attempt to perpetrate kidnapping, thereby committing the offense of first-degree murder in violation of TCA 39-13-202. It's generically known as felony murder. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge? Count two, you're charged with having committed the offense of especially aggravated kidnapping of Holly Bobo in violation of Tennessee Code Annotated 39-13-305. Do you understand what you're charged with on that count?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Count three of the indictment, you're charged with having committed the offense of especially aggravated kidnapping of Holly Bobo in violation of Tennessee Code Annotated 39-13-305. Do you?
Yes, sir.
Count four, you're charged with having committed the offense that you did unlawfully and with intent to commit rape, kill Holly Bobo in the perpetration of or the attempt to perpetrate rape, thereby committing the offense of first-degree murder in violation of Tennessee Code Annotated 39-13-202. Do you understand what you've been charged with in that count? Count five, you're charged with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand what you've been charged with in that count? Count six, you're charged with having committed the offense of aggravated rape of Holly Bobo in violation of Tennessee Code Annotated 39-13-502. Do you understand what you've been charged with? Count seven, you're charged with having committed the offense of aggravated rape in violation of 39-13-502. Do you understand what you've been charged with? Count eight, you're charged with having committed the offense of premeditated first-degree murder of Holly Bobo in violation of Tennessee Code Annotated Section 39-13-202. You understand what you're charged with?
Yes, sir.
Mr. Maddox, do you waive formal reading of the indictment?
Your Honor, we have received a copy of the indictment as well as I've given a copy to the defendant, and we will waive formal reading of the indictment at this time.
Let the record so reflect. Pleas of not guilty as to all 8 counts will be formally entered on his behalf.
Yes, Your Honor.
Do we have the same situation concerning any motions in the old case?
Your Honor, I did have motions that I filed underneath the old case. What I was asking for in those motions is that discovery be provided. I've been assured by the state and that is
I
forthcoming.
think you're going to get more than you.
I think that's probably true, Your Honor. But I do need that. And as long as it's forthcoming at this time, I do not need to proceed on with those motions under the same circumstances that.
Those files will not be closed until I've either been advised that the parties no longer wish to present them or they've been disposed of.
Yes, Your Honor.
Okay?
Your Honor, there are a few other matters that I do need to address the court on under the new indictment, I guess you'd say. It's my understanding, or at least some of the other attorneys may have indicated that they do not wish to file the motions again. However, in light of the notice given by the state of Tennessee today, I will be filing all of my motions again due to the heightened scrutiny that notice brings with it. So I will be refiling those, but I would like
Mr. Maddox, I've been dealing with you for how many years?
more than either one of us care to talk about,
Since
John.
the memory of man runneth not. I'm very familiar with what your computer generates in virtually every case that I have.
Yes, John.
I anticipate I will be seeing that yet again.
Yes, John.
Okay.
However, if the state will agree to the same orders that we have already agreed to under the first case, then that will belay any argument of those motions.
All right.
That's for record-keeping purposes.
Okay.
John,
All right.
For any appellate.
So anything else, and then, as I said, we'll be looking at August 26th. That's not a deadline for motions or anything. It's just an early hearing date if there's anything that's dispositive or that the parties feel particularly need the court's attention.
Your Honor.
And I will say, in thinking of this case, I've tried very hard since the very beginning to get this thing on track. There are times that I felt like the children's game, the whack-a-mole. I'll whack it down and I'll have two more pop up over here. But I hope that we're past the primary obstacles and surprises in this case, and we can take this to a reasonably expeditious conclusion.
Well, the number of years that I've dealt with you, Your Honor, I've never been whacked by you, and I hope I don't get whacked now. Your Honor,
I don't have friends or enemies, all right?
Thank you, Your Honor. Your Honor, the other issue that I would like to address is the state has said that they will be providing an index to this discovery. If I could impose upon the state to also make available someone who is aware of the current organization of the material on the hard drive and make that person available to me so I can understand the organization that as it is,
As I
and also
understand,
the
they said
different file
they're
types.
willing for a face-to-face exchange.
And I had the same discussion with Mr. Maddox that I had with the others. We've already had a face-to-face or two, and that offer remains on the table as well. I'm not at this point, because we've already copied the discovery, not going to reorganize it. The index, along with the face-to-face, will point him where he wants to go.
Okay.
Certainly.
All right. Anything else?
Finally, Your Honor, the previous cases were all individualized as to the defendants. Now with the new indictment, all three defendants have been brought underneath the same case number. I would ask that all parties in this case, if they would include all of the defendants and all of the attorneys on any certificate of services, so we could all receive copies of motions and other responses.
I have no problems. Ms. Thompson, you all right with that?
I agree.
Mr. Herbison? Okay, same over here. And Mr. Herbison, you've had some change of address. If you'll get various counsels, the address as well as the clerk's office, and also Ms. Carroll, okay? All right, anything else on him?
No, Your Honor.
Anything else we need to deal with today as to any of these defendants? Anything further from the state?
No, sir.
Anything further from defendant Zach?
No.
Autry? Jason?
No, Your Honor.
All right, then we will, Dylan, I beg your pardon. Then we will hereby adjourn. All right. Zachary Adams, motion 48, joining that motion. Also, Zachary Adams, 21, consider all objections under both state and federal constitution. Zach Adams, motion for higher standard due process. I've already mentioned at the outset, the court is aware that there's a heightened due process in death penalty cases. I will apply the applicable law to each motion on a motion-by-motion basis. Zachary Adams, number 2, motion to sever trial of Zachary Adams from Dylan Adams. State earlier filed a motion to sever. I'm reserving any severance until the court makes certain other rulings, because those rulings will impact whether we have 1, 2, or 3 potential trials. So motions to sever will not be ruled upon at this time. Number 7, Zachary Adams, motion regarding hearsay. Motion seeks to have the state specify any hearsay it intends to present as evidence in order that a pretrial ruling in limine may be had on the admissibility of the same. Motion seeks to have the witness admonished to refrain from the admission of hearsay testimony prior to the court's ruling. I intend to follow the rules of evidence. And all I can say is that if you think that something's hearsay, you need to object based upon hearsay prior to the witness attempting to respond, and I'll make sure the witness does not, and then you'll get a clear ruling on it. Motion number 16 of Zachary Adams, motion to instruct the gallery. Court seeks to have the court admonish the gallery and spectators during the trial prior to each session and out of the presence of the jury to remain from audible commentary, visible reactions, emotional displays, or outbursts during the presentation of evidence before the jury, and to prohibit the wearing or display by spectators of any insignia, symbols, pictures, clothing, or other items that might influence. The state believes this motion is unnecessary and the court may manage courtroom decorum. I addressed this at the very outset. I intend to basically maintain proper decorum in the courtroom. I will not suffer outbursts in the courtroom. There will not be T-shirts, other things in an attempt to any way influence jurors. I think we got problems anyway with jurors influenced by a T-shirt or a ribbon, but the court won't suffer it. I recently tried a case in Benton County that was not nearly high profile, and I just caught the people coming in and they had certain types of shirts on. I said, cover them up. You're not going to do that in the presence of this jury. So court intends to maintain proper decorum. Zachary Adams, number 18, motion to prohibit display of exhibits until admitted. I'm not sure exactly. I'm going to, in other words, opening statements, parties might wish to address something, but an exhibit is not evidence until it's properly admitted by the court. I'm going to ask that the parties carefully watch what they make reference to. Recently, I had in a case a PowerPoint display that I think probably went beyond what it should have concerning evidence. The jury's always instructed that they'll rule only based upon the evidence in the law, but I'm going to ask that all parties guard in their opening statements. Getting too far out on a limb is what I'm saying. Zachary Adams, number 19, motion to establish procedure to view exhibits. I'm not sure exactly what that is. Prior to anything being authenticated or moved into evidence, certainly counsel for each side have a proper opportunity to look at that. That really should be done pre-trial in order to expedite. I'm assuming she reminded me that's when the attorneys were viewing certain things at different physical sites. Yes.
Yes, Your Honor, that was for us to, the court to give us some instruction as to how it could be that the parties could look at the evidence that's in the custody of the state. We refer to it as exhibits because on many of the lists, the state has referred to items as exhibit numbers. But it was just we were looking to the court to provide some guidance as to how it was we were to look at
Has this been resolved?
It has not been resolved, Your Honor, no.
Then I expect the parties in a professional manner to resolve it. This is not something that should require court intervention. You have the right to have a certain amount of privacy while exhibiting, if this is where it's going, but it's not unfettered.
We didn't ask for unfettered, Your Honor. We would like to view the evidence without the prosecutor present. There could be an agent or somebody else present, but the prosecutor's office doesn't review evidence with us present. We would like to be able to review the evidence without the prosecutor present.
Can we designate an agent to take care of this?
Excuse me. The problem, Your Honor, with what counsel is requesting, and we have actually attached photographs to our response showing the thousands and thousands and thousands of items. Every single time one of those bags is opened, it requires one agent to open it, one agent to take it out, to display it, another agent to repackage it, to move on. So we were all doing it at the same time. The state was not hovering. And it's interesting because all of us were present to avoid tying up the entire agency, TDI I'm referring to, for days and days and days and days. The only person who complained is Zachary Adams' attorney. It was fine with everyone else. They were free to stop the process, to go and confer, to look at something, to photograph it. It is a near impossibility to ask TDI to do what counsel's requesting. In terms of designating an agent, and she, frankly, one of the requests was that an agent be designated that didn't have anything to do with the investigation. I'm not sure where all this personnel is supposed to come from, but we did our very, very best to make sure we did it.
Did we have any problems with the procedure?
I did not, Your Honor.
All right. Y'all have any problems with the procedure?
Your Honor, it was my understanding at the time that we could come back at a later time.
Yes.
Individual items if we needed to.
Okay, the court finds that the state is sufficiently complying with what the court feels should occur, and you might have to come her way a little bit on this, okay?
It's fine that the district attorney stands next to me. I mean, at some point, the district attorney stands so that.
I don't want it like the Saturday Night Live skit of Trump right behind Hillary following her around. She's got some, you know, we're human beings. You'll be given a certain amount of privacy, okay?
Yes.
All right. Zachary Adams, motion to continue, overruled. Related motion, Jason Autry, motion to continue, the trial date set April 3rd. I had mentioned at the outset that since Mr. Autry's attorneys came into the game later, that we will not hold them to that April 3rd date. They will be held, however, to the July date. You came in following two other attorneys. Mr. Shaw came in first, and then Mr. Parrish came in. You folks were later into the game, so I think I can give you at least that much relief. You will not be that first trial date, okay? I think that's it. Anything else? She'll get you an order. If we did not cover your motion, call that to the court's attention, and the court will do another order covering your matter. All of these are basically, they're non-evidentiary. It will get much more complex when we're taking up evidentiary motions, but I think for the purpose of today's hearing, that all these matters have been covered.
We had it the first week of July, correct, Judge?
No, it's toward the last of July. 10? Oh, I got this neat book here. No, July 10th. July. July 10th. I got July 31st. I can do it the 10th. What did y'all get?
We have it the 10th. The first week in July was discussed as potentially starting jury selection the week before trial was supposed to start on the 10th. But Your Honor did not ever definitively rule. I think most of us just sort of blocked it off, waiting to see.
We talked about coming and taking a jury a little bit earlier.
But there was some question about it with it being July 4th week, but we did have that discussion, but the 10th was.
All right, July 10th will be our trial date. What have I said repeatedly? She's telling me I've got grand jury in Hardin County during that time. Well, guess what? I don't either. I've told you folks, you've got priority on this case. I've said that from the outset. This case has absolute priority, and once we get things going, I will not be interrupted. I don't think I'm going to. First trial date is April 3rd. That could apply to either John Dylan Adams or it could apply to Zachary Adams. Autry, I'm telling you, I'm giving you till July 10th, okay?
Your Honor, I didn't discuss Autry motion number 30. If you'll grant that, we'll just probably speed things up. Otherwise, we could hold that in May.
What is 30?
For you to strike like that.
Motion overruled. I told you I'm following existing law.
Yes.
And so you can, that motion be deemed overruled.
We let the judge create and submit it.
I think everybody over here is.
Crickets over here.
Do what?
Cricket.
No, I'll let you preserve your arguments there. All right, anything else? And I think I mentioned down the same avenue, we're not having two separate juries. It's bifurcated for penalty and sentencing, but we're not having two separate juries. I'm not prohibiting from going into death penalty with voir dire with the jury panel. I think those were part of the motions, but I told you as we went through that I would follow existing law on that. Yes. All right, anything else? All right, no need to kill a bunch more trees, I don't guess, but, and this is only a portion of what I've got.
All right.
Be seated, please. Just a few preliminary matters. First of all, we've got all three defendants. Got you seated where you can communicate with counsel should you need to. I will tell the defendants you are not to communicate with anyone except your lawyer or directly with the court. Okay, we understand that? Mr. Autry, you understand that? No communication with anyone other than your attorney or the court. You understand? And then Mr. John Dillon, you understand that? All right, there's a slight change. Most of our motions today are the more technical motions. They're not evidentiary motions. Those evidentiary motions will come later. These are essentially, I would classify them as housekeeping motions, but I will tell the attorneys, first of all, I'm guided by Tennessee law. I don't make law, I follow law. I'll be guided by the Tennessee Code Annotated, case law, the Tennessee Rules of Evidence, as well as the Tennessee Rules of Criminal Procedure. A lot of the motions that have been filed address issues that are actually addressed in those rules. I'll touch on them as we go through, but those rules are what will guide the court. There's a slight change. Our next potential hearing date, I originally had said December 13th. That's in conflict with Chancery Court here in Decatur County. We've got limited facilities. There's one courtroom, and I've got additional time so I can defer to the chancellor on that day. I also avoid setting things in Decatur County on Mondays because that's the traditional general sessions day, and Decatur County is not high volume, but I don't want to deprive that general sessions of their opportunity to move their cases through the system. So our next potential date here is December 14th. I've got 3 days available at that time, although I don't anticipate that it will take 3 days. If we don't accomplish in those 3 days, the following week, I cannot be back until the 21st. That's a Wednesday. Yeah. Okay. I'm sure you've checked me out before with fellow lawyers or judges. You're not going to go past 3 days, okay? So I'll just let you know that. But if it appears a problem, we'll work it out, okay? And then there's potentially some dates I can make myself available, and some of that will depend. You've got a motion, Mr. Maddox, for extension of time to file a motion to suppress. And I'm worried that the timing of your motion could trigger response and potential examination by the state that might put us past that December date. When can you have your motion suppressed ready to file? I'm just anticipating. Am I anticipating correctly?
You are, Your Honor. That can happen.
Your Honor, upon discussing with the co-counsel, we think we should be able to have that file.
Okay, that will potentially jeopardize that December date. We'll cross that when we get there. I will tell you, I've got January, I got 3 days starting January 11 available. And also, what did we say in February?
The 6th, 7th,
6th, 7th,
and 8th.
and no, see, the 6th won't work, 7th and 8th in February. 6th is that Monday. So, filed by November 30, state filed their response, and then we'll calendar it for hearing on one of those potential dates. If the state makes a motion for evaluation in response to their motion to suppress, then that will be granted ample time to get that done. And we're also dealing with holidays, which makes things iffy for all parties concerned. So I've already issued an order on some of the motions that were purely technical. John Dillon Adams, motion number 1, to require the state to comply with provisions Tennessee Rules Criminal Procedure 26.2 is granted. There's already been an order to that effect. John Dillon Adams, motion number 6, notice and motion under Rule of Criminal Procedure number 16. And Zachary Adams has motions that are piggybacking. It's Zachary Adams number 30, Zachary Adams number 35 for discovery and inspection. There's already been orders entered on those. John Dillon Adams, motion number 6, under Rules of Criminal Procedure 24B2 and 24H. Zachary Adams, motion 36, joining for individually sequestered voir dire. There's been a motion entered as to that. We will have individual voir dire, certainly on the issues of pretrial publicity, hardship, death penalty. And I will address later, but the court's open to questionnaires that will hopefully expedite these issues that can be filled out by jurors pretrial. And John Dillon Adams, motion number 7, and Zachary Adams, 36. Oh, the state's motion for reciprocal discovery was granted, and Jason Autry concerning reciprocal discovery and disclosures of experts. The state's complied with disclosure as to all 3 defendants, so you can show that that is granted upon their, they've already complied, because I've got a bundle as to all 3 of the defendants on that. Matter of fact, it scared Miss Carroll to death when she looked, and there was 200 and something pages from the state, but that included correct. They've already turned it over. I was talking about 24B2 and 24H, John Dillon Adams, Zachary Adams, number 36. As I said, that's individually sequestered voir dire is granted. Motion for change of venue will not be granted at this time, but the parties can assume that the court will grant a motion for change of venue at some point. I want to leave it in this county as long as I can, because convenience of family members of the alleged victim, as well as defendants and interested parties. So we will not change venue until on down the road, but I will tell you, venue will be changed.
I'm going to make this request as we're talking about venue. I would ask that there are ribbons and things all over the.
This is a good time to do it. It won't affect the court, but it potentially could affect jurors. There will be an order of decorum that will be filed where this case is to be heard, and I will not tolerate signs, placards, T-shirts, anything like that that could be perceived as trying to influence prospective jurors. So that will go into effect wherever the court deems the appropriate venue is. And I will go ahead and tell you, just for thinking purposes, the physical change of venue in all likelihood will be Hardin County. I've already explored security and other issues. We can have very, very good security. We can, the housing of jurors can be taken care of so that they'll be sequestered appropriately. There'll be alarms on the elevators as well as the stairs, and sequestration of jurors can be accomplished there.
And Your Honor, I neglected to advise defense counsel and Your Honor, but I have received notification from the Department of Homeland Security for the courthouse, and I have the number that your personnel to give to the sheriff or whoever you designate to get it there.
There will be medical detectors, metal detectors, as well as x-rays, and potentially the dogs might be run some.
Well, they said as soon as you tell me who to give that information to, pass it on, and they'll call and have it physically relocated.
Okay. I'm also reserving the issue of where the jury is to be impounded. It could potentially be hard to see. One of the attorneys suggested Shelby County. Anyway, further than say it, they said suggest Shelby. That issue's still open, so we'll wait till we're closer to know which way the court's going to go. A motion to change the venue will be sustained, but not until later, okay? Once that motion is sustained, files and everything will immediately to the other county. Mr. Tanner's doing a fine job up here for right now, although I'm sure he'd be glad to load him in his pickup truck and take him south when he is able to do so. Disclosure of expert testimony, disclosure of facts, data, underlying expert testimony, qualification of expert testimony, that's Dylan Adams 15 and Zach Adams 44. Also Zach Adams number 5. Essentially, ordered that Dylan Adams motion for leave, file additional motion, Zachary Adams, that's number 20, Zach Adams, 45, Jason Autry, 11, 26, and 5, 40 for the that. Dylan Adams, number 21, motion and notice of joining of all co-defendant pre-trial motions. That's the one that Zachary filed motion 28 to adopt. I've asked that and ruled earlier, we don't do a blanket motion to join all motions. They specifically will file if they're joining motion number, whatever it is. Zachary Adams motion regarding rule 1006 summary of reports document. File same motion, and related motion is Zach Adams 60 joining Autry 25. That is granted. Motion for bifurcated jury, 15 on Zach Adams, Jason Autry number 18 for separate. I think I have ruled on that, but I will follow Tennessee law. We don't get different juries for penalty phase and guilt phase. Yours will be voir dire as to the entire trial. That will not be bifurcated, and then extra alternates so that we can cross that penalty when we get to it. So I think I've already ruled on that, but that will be what the court's reading. Motion for jury questionnaire, that's Zach Adams 15, Jason 19. State also, Zach Adams, motion 54. Jordan Autry number 9, and state filed motion as well. As I indicated earlier, I intend to use jury questionnaire. We agree between all parties. In other words, probably I will get Ms. Jones to first fire across the bow and then send it to each attorney for suggestions or narrowing or whatever. I think we should be able to agree with that as problems. Zach Adams motion should be closed. That's absolutely established in Tennessee law. That when we're before the jury, there cannot be any indicia that any of these defendants are incarcerated, because that's been ruled to perhaps detract from the presumption of innocence. So makes no difference on a hearing like this today because the court's ruling, and it makes no difference to me what your parole is. Zach Adams' motion to dismiss, because I think that's where he said that and Autry's, motion to dismiss on the grounds that no grand jury voted to return Zach Adams, all of them. That's contrary to existing law. The grand jury doesn't have to vote on death penalty, they just have to vote on the criminal charges. Also, we ruled on Zach Adams, motion 24, dismissed based upon Lawson versus Gross. As far as Jason Autry, there's a motion for state to seek intent to seek death penalty. I don't remember what that is, but the court's already ruled on that. Jason Autry, number 17, motion for jury penalty on specifically for this case. Did I run on that? It depends on where I get my jury. If the jury comes from the same place of change in view, it will be a separate jury summons specifically for the case. If I go to Shelby, Chattanooga, another place, it might not be specifically summoned, I might be drawn from that pool. All right. I said it was granted, but it's subject to those qualifications, okay? Because there's no need for Chattanooga to have a separate summons for whichever case we're trying. Shelby, they've got that auditorium down there that's filled with yours. What I have done in the past when I was over there, I met with the jury, handed out questionnaires in the morning, and then fill those out, and then we started jury selection actually right after lunch. I ruled on Jason Autry's motion for probable cause hearing on the existence of aggravating factors. State that motion for notice of alibi defense which was granted. Motion state that motion for notice of defense based on mental condition which was granted. Get into the discovery related motions. Dylan Adams filed a motion to produce exculpatory evidence or information which might lead to exculpatory evidence for the defendant. The state filed a response that court kind of questioned. Without a theory, without a statement from the defense as to the theory of defense they would be pursuing. I don't know anything under existing law that would require a defendant to disclose to the state a particular theory of defense. The court is ruling that the state must, pursuant to Brady, produce evidence for each defendant. And I'm very serious about that. I don't expect any problems. You folks are used to doing that. So let's not play it close to the chest. Anything that is of any question whatsoever should be turned over to the defendants. And I'm aware from various things the court's done that states, through their discoveries, fully compliant. Let me just say that. As to some of the potential theories for defendants, the state has been very forthcoming with other potential defendants and other things that have been raised in motions. I expect them to continue, and there'll be a continuing duty to disclose as we go through. Dylan Adams' motion in limine under rules of evidence 404, 405, 608, and 609. Zachary Adams also joined in. Do motion 32. Motion seeks a pre-trial or jury out hearing for any reference to any prior conviction or bad act of the defendant. Certainly that is required. The defendant seeks an opportunity to go out and cross-examine any such witness in pre-trial or jury out hearing. And the state has responded that it is mindful of its obligations and expects the court to follow 404, 405, 608, 609. But they state that the motion exceeds the provisions of the rule. notice at least 90 days pre-trial of 404B evidence and seeks pre-trial rulings. Seeks that the state admonishes witnesses not to mention the same prior to a bench conference for the sake of trial. State responded that same as above and asked that the motion be denied. We're going to try to rule everything we possibly can pre-trial so that it will facilitate the case moving along, because it's going to take a long time to try doing the best we can. Jason Autry, motion for pre-trial disclosure of evidence of the crime from during acts and for a pre-trial hearing, that will be granted. Motion pre-trial on the record findings pursuant to 434. Zach Adams joined in that, joining Autry, do everything I possibly can in pre-trial. Got to go across that, I'm hopeful that the parties are having some type of dialogue for resolution of the case. That's up to the parties, it's not up to the court. So, when we get down closer to trial and we realize if we've got 1, 2, or 3, which I don't know yet what we've got to be tried, then we will set time deadlines for pre-trial motions to be argued so that it can facilitate. All right, Dylan Adams has a motion under Tennessee Rule of Criminal Procedure 12B2C. Zachary Adams has a motion 33, joining John Dillon's number 4.
Your Honor, that's the motion. We were earlier on there.
That you're gonna have time November 30th.
Yes, Your Honor.
Is it
It will be supplemented, this is just.
okay, all right, so you know what the court ruling is on that.
Yes.
Dylan Adams, number 5, motion for introduction under Tennessee Rule of Criminal Procedure D2. Zachary Adams is number 34, joining this motion. Defendant seeks a Rule 12D2 notice, which the state has already filed. The state did reserve the right to supplement the notice as reasonable and necessary pre-trial. The state indicated in its notice that because the issue of severance is currently pending, same notice has been filed as each defendant, and the state points out that any co-defendant could be a potential witness for the state. The state also noted that it will continue with other file discovery.
Judge, I'm just going to say, just for the record, that each of these, some of them are obviously titled differently, that most of them say I'm granted for the most case.
Yeah,
I just want to put that on the record.
absolutely.
Thank you.
If you want to, just one order say that I didn't follow law. Okay, because it's just technical crossing the T's and dotting I's, and a lot of that has to do with the standard that cases. Normally, I wouldn't be pleased that the attorneys are killing the number of criminals they are, but I understand. Okay. That will be granted and is complied with by their request. All right, Zachary Adams, motion number 3 for Rule 12B2, notice of evidence. Jason Autry, motion 14 for notice of state's intention to use evidence. And related motion, Zachary Adams, number 49, joining Autry's number 14. The state has provided the same notice in response to each defendant. These motions are essentially granted by the court, and the court did not comply with continuing use disclosed. If the defendants have any specific issues with the 12 state cites open file, its alibi notice, and states that info requested is neither necessary nor appropriate. I don't want anything destroyed, is what I'm saying. And I know that there are any number of rough notes, anything else. I don't want anything destroyed so that we can assure that full compliance with Brady's being accomplished. Zachary Adams, motion number 8 regarding 804B3, exception to hearsay statements against interest. Wants the state pretrial to specify in writing and with particularity all statements against interest that the state intends to introduce at trial, and the court to hold a pretrial hearing on the admissibility of the proffered testimony. The state has responded that its filed 12D2 notice has provided open discovery and will supplement as necessary. So any statement against interest, essentially you'll get that. Motion number 26, Zach Adams, motion for pretrial review of victim impacts evidence. State does not object, but states that it is sure the court will follow appropriate procedure. I hope so. The parties will need to follow procedures set forth in the Nesbitt opinion, and the hearing need not be pretrial. Matter of fact, this is something that can be done sometimes while the jury's deliberating the guilt phase. We can check, make sure that testimony during the sentencing phase is appropriate. Number 29, Zachary Adams, motion for agents to provide evidence to the prosecuting attorney. Jason Autry, motion for all agents, officers, and employees to disclose and provide evidence in the possession, custody, and control of the state. State submits this motion is not necessary based upon open file policy. Motion's intended to avoid any issue of an agency failing to turn anything over to prosecution. I think the parties have been cooperating to make sure that all the information that's out there gets from agents to the prosecutor's office and it'll be furnished to the defendants. Jason Autry, motion for disclosure of informants. States comply by the rule 12D2 notice. Jason Autry, motion for preservation, production of evidence sent to other agencies. Motions to seek preservation of evidence in the event defense needs to have it independently tested. State has responded as unaware of any such evidence sent to another agency which has not been returned. So it's in their possession. Should it require independent analysis, that will be granted. Trial-related motions, Dylan Adams, number 14, motion for exclusion of witnesses, and for the immediate instruction to all potential witnesses for enforcement of Rule 615. The court will closely enforce the sequestration rule and will instruct all witnesses that they're not to discuss that testimony or matters that have occurred in the open courtroom. Okay. Everyone in court will be advised that they're not to discuss testimony that's given in the courtroom with other people, but all persons without limitation might be brought, but court will fully.
Identify himself? Yes, and you chose to remain quiet. Usually, I'm sorry, my question, you chose.
Let's get you at council table since you're going to be engaging in some oral argument. I think he needs to be present with his counsel. there might want to be some discussion as we go through the process. Told the clerk to announce that we might be a few moments late starting. As late as 9:30 this morning, there had been additional filings on behalf of both parties, and perhaps I need to go take a speed reading course so that I can move through it quicker, but in fairness to all parties, I wanted to give due consideration to the matters that have been filed in this case. The initial part of this hearing is reserved for one issue only, and that's the motion for the court's recusal. Because the rules are quite clear that until that is resolved, I cannot have any further action in the case. So your argument will be confined to that, probably be a short recess, and then I will make ruling on that. In the event that I am not recused, I will then proceed, unless I stay myself, which is unlikely. The rule provides that I can stay the case or the Court of Criminal Appeals can stay. I think it's imperative to keep this case moving. So in the event that I am not recused, I don't intend to stay any action by this court. I'll go ahead and let you know that on the front end. I don't think that comes as a surprise to anyone. So I'll give you an opportunity to speak over here on the issues that are solely confined to the court's recusal. I will take a brief recess to try to gather my thoughts, and then I will make ruling in the open court with the findings of the court. Okay? Ready to proceed, Ms. Thompson?
Yes, sir.
And I'm going to also, I will apologize in advance. I've probably done it before in discussing matters with her. I've got two Jennifers, and sometimes I'm calling her Jennifer Nichols. I've probably called you Jennifer Thompson. I apologize. I clearly know the difference between the two actors, and it's just sometimes the wrong thing comes out of the mouth, okay? So, Ms. Thompson, the court will be pleased to hear you.
Yes, Your Honor.
I've even drawn myself a chart. I write the name of grand jury for people so that people that I've known for 20 years, I won't suddenly forget their name. So I've got you charted, but I put you in the wrong seat, so I've got errors. So hopefully that will prohibit misidentification. All right.
Yes, Your Honor.
Ms. Thompson, the court will be glad to hear you.
Well, I'd like to put some proof into the record, Your Honor. So
Okay.
that I could make proof in the record. I'd like to call Erin Honeycutt at this time.
Okay.
She was my assistant, just to put proof in the record as to what was the substance of the telephone conference that morning.
Okay. State have any objection?
No, Your Honor.
I'm going to let you put that proof in the record. In the future, any telephone conferences, she ought to be identified as being present, because I specifically identified who was present on that call and who was not. And maybe it's oversight, but there was nothing whatsoever that would identify her as being present, taking notes, transcribing, anything else. Okay?
Yes.
Come around and be placed under oath, please. I'll do it. I'll do it. Up here. Raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, be seated.
Would you state your name for the record, please? And how is it that you're employed? Okay. And so on Tuesday, January 23rd, were you aware that there was a telephone conference set up between the parties in this case?
The date again, I know it's all throughout.
24th,
24th.
January 24th.
Okay, which was a Tuesday.
And were you on that telephone call? How was it that you came to be on the call? And what was the purpose that you were on the call? Okay. And are you usually present on telephone calls? Okay. And did you in fact take notes on that day? And how is it that you took notes? What program did you use to take notes into?
Operating system that has a calendar, and you just click on the day and time, and the event was.
Let me say, acoustics are not very good. Mr. Walker just squeaked his chair. I'm not going to tell you not to squeak, but you need to speak up a little because acoustics are not good in this courtroom.
Okay. And what kind of system is that?
It calendars events, it holds all of your case matters, communications, calendar events, time notes.
Okay, so when you put these notes in, what kind of little section then did you put these into?
Description box of
For the event?
for that event.
Can you explain what an event is?
The event is a marker on a calendar.
Okay. And I'd like to pass that to you. These are the.
They were attached to the pleading.
Do you recognize what it is that I have passed to you? And what is that?
These are my notes from the teleconference on June 24th.
Okay. And you took them while the conference was going on?
Yes.
Have you edited them since that time?
No.
Okay. And so while you were on the telephone call and you've taken notes, can you please, for the record, tell us what it is that you recorded there in your notes?
Do you want me to go through kind of the?
Yes.
Okay. So I connected in on a call and Jennifer, Luca, and Jim Simmons, she's the middle, Eric Christensen, Steve Ragland, Paul Hagerman, and Jackie Denley were there, or came in on the call. There was a remark about Susan, and then it was quickly discovered, somebody said the name Mary Ann, and it was quickly discovered that it looked like two parties were on the same line, and so the other party hung up. And so then the judge stated that he invited Susan Jones in on the call, but she had a death penalty case in Upper East Tennessee. He then said that the reason for the call was that he had approved after a pretty, say about 20, 30 minutes conference with Jennifer and Jim, a third attorney. Technically, it's not in compliance with the Supreme Court rules, but they had a good argument, and that was the Dillon Luke case. They suggested Luke come onto the case because it would take less time for him to get up to speed because of his involvement with Shane Austin. And under the immunity agreement, and it was in the process of being revoked at the time of Shane Austin's death. But he did have two questions, and he'll give Jennifer and Jim a chance to make sure that he's right. One, do they understand that April 3rd is the trial date if there's no plea? And then two, what about the conflict of interest? He indicated, Luke assured them that there's no conflict of further communication, and further communicated that with the Board of Professional Responsibility, and it had been confirmed. He issued an order saying that Luke, could defend Zach. It was up to the AOC to decide if it was in compliance for purposes of payment for indigent attorney fees. This is Tuesday. The judge was kind of hard procedure, but not now. He was in Carlos. As of Friday, the AOC had not approved it, told them to pay. The director of AOC was rejected. What was to occur was that unit would be submitted to Bivens for members of the Supreme Court to decide if they go beyond two death qualified attorneys. As of Friday, it was not approved. Mr. Evans had submitted his bill. Judge McKinley approved it, but not paid. But it has not been paid because it's not yet been approved. And then he asked Jennifer and Jim, is that accurate to this point? Jennifer said yes, that she did not know about the not approved part. And the judge said, as far as the background of what he did, is that accurate? Jim Simmons says correct. And the judge asked, did anybody have anything to add? Jennifer said, get the conflict of opinion from the board before submitting. Also, the client signed a waiver of any potential conflict. The judge said, I do not understand that. So then Jennifer says, I have signed a written waiver of potential conflict. So the judge said, fast forward. I got a call from Jennifer Nichols on Friday. She said she was worried about a conflict. I know they say the board says it's okay. She didn't raise. DPR might result in censure of some type of warning, but when a new dimension when we're dealing with the death penalty, I told her to discuss with Jennifer and Jim and see if there was a way to work around that. That was not able to be accomplished. Jennifer Nichols expressed she's concerned about the settlement negotiations with the appearance of conflict. Jennifer Nichols, is this accurate? Jennifer Nichols says, you are. I did speak with Jim Simmons and advised my concerns over the issue after I spoke with you on Friday. I spoke with Jim on Friday and Saturday. Jim Simmons said, there was no resolution. We don't think there's a conflict. Zach Adams signed a waiver of conflict. He would be deprived of his right to have Mr. Adams represent him. The judge said, well, not deprived representation. Adams may be pro bono. Jennifer Nichols asked the judge, the prosecution team to set out for your honor, and depends what our concerns are. The judge then said, I think the appearance of conflict is so strong, it makes it apparent Evans is no longer going to be able to represent Zach. This might reflect poorly in the confidence of judicial procedure. I'm going to disqualify Evans at this time. Prosecution, judge said prosecution make the order and the findings in the appearance of poor confidence in judicial procedure. Then Jennifer said, Your Honor, we had this hearing, not on the record. I've just had it again on the record. The judge said we will have it on 3-1. They hope to wrap the case up by then. Jennifer said, I'm going to want to file an appeal on this. This is an appealable issue. The judge said, you can be ready for whatever on 3-1, maybe an interlocutory appeal and I'll rule on it. My strongest suggestion is no negotiated plea before then, be ready for trial on 4-3. They were there. And Mr. Evans is invited to attend. Jennifer Nichols then said on February 1st, put it all on the record. The judge said yes, it still remains. If I were representing Zach Adams based on movements and what the court has inevitably occurred, like I said 3 months ago, if I were defense, I'd be beating down the door at 101 Poplar to see if I can get something reached. Any way to resolve 2-1 it needs to be. And the call will be at 10:15 a.m.
And do those notes reflect your recollection of what was said on the call? And so that's all I have.
Counsel, the judge, and the prosecution. Yes. You take notes of those as well. Yes. So I'm sure that you've heard for at least the last 2 years, judge encouraged all parties to engage in productive settlement negotiations. Haven't you? Yes. You've heard him say that from the bench. Yes. You take notes here in court? Yes. Okay. So then you probably actually heard him say that exact phrase before, either on the bench or on a telephone, where he encouraged people to come to Memphis, to my office, and engage in settlement negotiations. No, I don't. This is the only time that you wrote that down.
I think this is the only time I actually heard you say that.
And you would agree then that on this particular teleconference, the one on the 24th, you heard the judge take a roll call, didn't you?
I did.
Okay. And you heard me identify the 4 attorneys from Memphis, right? Yeah. You heard Ms. Thompson identify herself? Yeah. Mr. Evans identify himself?
Yes.
Mr. Simmons identify himself?
Yes.
And you chose to remain quiet?
Usually.
Jennifer, sorry, my question, you chose to remain quiet?
I was muted.
So in answer to my question, you chose not to answer the judge's question about who was present on the teleconference. have you also done that same process on every other teleconference that the judges had with the defense counsel and with the state?
I'm usually physically in the same place with Jennifer and the calls on.
Sorry, but maybe my question's not clear.
Yeah, I'll never directly address the court, no.
So every single time that we've had one, you have remained quiet and not responded to his honest question.
This time, I don't remember a roll call for, but yes, that's correct. I remain quiet.
If you don't remember a roll call, that's fine. So I'm going to ask you another way. Have you ever identified yourself as present on the teleconference between the judge and defense counsel?
Not that I remember.
One moment, John.
Address something else. You've got my telephone information. You've got my office. You've got my cell phone. You've called on many occasions for scheduling purposes.
Okay, I think June is trying to get us to switch over to the Slender Man Redrum trial, escape of Morgan Geisher, so we're going to switch. June, do we have sound?
We go from here. Our governor's office is also in contact with the authorities to see how they can best handle getting her from Illinois back to the custody of Department of Health Services, which is whose custody she has been in since she was actually committed by the court. With regard to what happens from here, once Ms. Geiser is brought back to Waukesha County, it will be up to Department of Health Services whether they file a petition to revoke her conditional release. We are certainly
Bring yourself in. Looks like we may be having some movement there inside of this area there in Waukesha County. Let's listen in.
And sit on the public information officer here with Waukesha County. District Attorney Leslie Basie and Assistant District Attorney Abby Nicolai are here today to go over Morgan Geiser's procedural timeline and potential next steps here with Waukesha County. Any investigative questions you have about what happened over the weekend in Madison should be directed to Madison Police. So I will bring up District Attorney Leslie Basie first to kind of talk about her reaction to what happened with Morgan Geiser.
Thank you, Hillary. And good afternoon, everyone. I just found out yesterday about the escape, Morgan Geiser escaping from her placement in Dane County. As Hillary indicated, I'm not here to talk about that investigation. My understanding is that the Dane County law enforcement is investigating her leaving her placement and what occurred after that. What we do know is that she left, she cut off her bracelet, she fled to Illinois, which is where she was arrested yesterday. Any charges, as Hillary stated, with regard to the investigation from her escape would be handled by the Dane County District Attorney's Office. We are grateful for the efforts of law enforcement, not only in Dane County, but also throughout the area, because obviously she was taken into custody in Illinois and is currently in custody in Illinois. In terms of what happens from here, there is an extraditable warrant for her arrest. We are verifying with Cook County, which currently has Ms. Geiser in their custody, as to where we go from here. Our governor's office is also in contact with the authorities to see how they can best handle getting her from Illinois back to the custody of Department of Health Services, which is whose custody she has been in since she was actually committed by the court. With regard to what happens from here, once Ms. Geiser is brought back to Waukesha County, it will be up to Department of Health Services whether they file a petition to revoke her conditional release. We are certainly hopeful that they do proceed with that. We fully support it. We support that she should be in custody. Not only should she have been in custody from 2014 forward, but also Attorney Nicolai argued vehemently for her not to be released to conditional release in, I believe it was January of this year. And therefore, we will be fully supporting a petition if one is filed. Obviously, our thoughts are with the victim and the victim's family during this time. It's unfortunate, but we found out yesterday morning about Morgan's escape. Victim witness was immediately notified of this information. The director of the victim witness unit, Jen Dunn, did reach out to the victim and her family. We were told that they had not been informed prior to Ms. Dunn reaching out to them that Morgan had escaped. And I'm able to verify that when we spoke with the victim's family, or when Ms. Dunn spoke with the victim's family at 12:20 this morning or this afternoon, they still had not been informed by any other agency other than our own that she had escaped, which is very concerning. While she was on the loose, we were very concerned about the safety of the victim and her family, as well as our community. We are continuing to assist them in this process. We are updating them. Our office is updating them as to what is happening, but that certainly was a concern that they were not notified of this in a more prompt manner. What we know is that there was a period of time between approximately 8 o'clock on Saturday evening to when she was taken into custody yesterday, in which she was not monitored by any person. She was on the loose and her whereabouts were unknown.
So we take this very seriously. Our office will not get involved again in this case until a motion to revoke for conditional release is filed. We will then go back to court. We will fully support that motion and that petition to revoke her conditional release. And we will then go before a judge to make a decision on whether or not she will be returned to conditional release or whether she would be returned to institutionalized care, which is where she came from. And that's all I have at this time.
Can you file that motion to have her revoked or not?
No, the state, we cannot, Department of Health Services, per statute, has to file that motion. She is in their custody.
Can you appeal to them or talk to them and request that? Or?
We are in contact with the Department of Health Services, but ultimately it is their decision.
So in March, Defense Attorney Tony Cotton said that a group home would have more restrictions in place than Winnebago. Was the DA's office receiving regular updates on Ms. Geiser's time at the group home? And if so, what was that day-to-day like and monitoring like?
I do not know what the monitoring was like. I don't believe that we received any updates, although I would confer with Attorney Nikolai. We did not. Obviously, he was misstating the nature of the monitoring that was taking place.
So the warrant that you're speaking of, is that issued by Dane County or the state or?
The Department of Health Services did forward that warrant to our intake judge last night, and the intake judge, from what I saw this morning, did sign that.
So it's a Waukesha County warrant?
Correct.
Because DHS requested.
Correct, and because the case is out of Waukesha County, that's why it will come back to Waukesha County for the decision in a petition to revoke her conditional release is filed.
All right, that's a little why this is a little confusing because is there a criminal case in Dane County then? Is that a crime to cut your bracelet off if you're not under a criminal?
So again, this is a Dane County decision. As I looked at the statute, it looks like you can escape, be charged with a felony for escaping under a 971 commitment. Also, if there was damage to the bracelet when she cut it off, which I assume that there would be, that would be a crime as well. But again, that's outside of Waukesha County's purview. That would be a decision. Law enforcement in Dane County, who leads the investigation, would refer charges over if they believed it was appropriate, and the Dane County DA's office would make that decision.
So just to clarify, I apologize.
No,
so the warrant that she would be returned to Wisconsin on would be a Waukesha County warrant. She would be returned to Waukesha County in custody?
That's what I believe, because it's still under the custody of DHS. But again, this is her home county for charging purposes. Therefore, I believe she will be returned to Waukesha County.
At any point down the line, could you guys press any other charges?
Not in Waukesha unless we have jurisdiction to charge crimes that occur in Waukesha. Because she was in Dane County, they would have the jurisdiction to charge any crimes that occurred in Dane County. With regards to the conditional release, her violations of that order, which were as a result of a Waukesha County judge ordering it, that would be what would lead to a petition to revoke her conditional release.
And maybe Abby can speak to this, I'm not sure, but what is it that about her leaving as far as her being dangerous, I guess, or danger to herself or others, which was the standard, right, that the judge went by, or at least that's what he said at the time?
Right. I think that one thing that is very concerning to me is that if and when a petition is filed by the department to revoke conditional release, it will be the second one that is filed, because we were here in March on a petition to revoke conditional release already. And so it's extremely concerning that you would so blatantly violate a very, very simple condition, which is to stay in the placement and keep a bracelet on. And that we have no idea what was going on is extremely concerning to the state, because immediately my thoughts went to the victim and keeping the community safe. But as additional information is gathered, that would be the kind of facts that are put into a petition to revoke. And that would be what is litigated at that motion hearing before the court, when I'd be able to gather more information, whether there are specifics about the dangerousness. But I think those blatant acts in themselves certainly speak to the dangerousness there.
There have been reports that there was a person in custody with her, or in her presence when she was arrested.
All right, there's more of this press conference. We do have to get to our break and hit the pause button, but if I told you so was a press conference, this would be it. The district attorney's office saying they knew this would happen. That's why they tried to stop her from that conditional release. Stay with us.
breaking down the biggest stories that are trending in true crime.
Opening Statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
Morgan asked me whether or not she should do it, and I just wanted it to be over with. So I said, just go berserk, do what you have to do.
I came up from behind her. I jumped on her. I tackled her. And I stabbed her. I just want to let Ella and her family know I'm sorry. Never meant this to happen.
That was Morgan Geyser in court when she was apologizing for the Slenderman attack. Let's go back now to Waukesha County, Wisconsin, and pick up the press conference, and we'll pick it up right where we left off.
That person, where they played a role in her misconduct.
We do not know any information about that person. That was information we had received that there was a person that was outside the placement's location, but I don't have any information about that at all.
But Abby, you were concerned at the earlier revocation hearing about people that were in touch with her even while she was still at Winnebago, correct? People, outside people that were contacting her, influencing her?
Right, there's a certain notoriety here that is of concern that there are people that kind of sought her out, that there was some concern about communication with those types of individuals. We also had concern at that point with what seemed to be kind of a pushback in terms of Ms. Geyser's acknowledgement of the extent to which she'd be monitored in terms of my reading material is going to be, that didn't seem consistent with someone that was ready to make that next step into the community.
But you have no way of knowing if this person was one of those that you were concerned about, was in contact with her at the time.
I don't know.
Would all of this happening impact a future request for a conditional release?
Certainly when those requests are made, I look back through the record in terms of assessments that have been done throughout the history of a case, and so I would say yes.
And just for the general public, because this isn't a sentence she was facing per se, but she still is under the control of the state, so there's leeway as to whether she is in custody or in state care facility or outside a facility. That's what you're talking about, trying to get her back to that previous level that she was inside Winnebago.
Right. Ultimately, if the petition to revoke conditional release were granted, she would go back to that institutional care placement, which would be a hospital facility.
Which is more secure, obviously, than community-based facility.
Right, exactly.
Could you walk us back just for clarity again on the process of contacting the Leitner family once it was clear that Ms. Geyser disappeared?
Certainly. I can tell you that I was informed yesterday morning about Ms. Geyser escaping from her placement. Prior to me even getting notification of that, I believe Ms. Nicolai and Ms. Dunn, who's the head of victim witness, also received that notification. Immediately, Ms. Dunn contacted the victim and her family to make sure that they knew about it. They did not know anything about it. We wanted to make sure that they were safe and that they had a plan in place. And I know that Ms. Dunn has been in contact with the family pretty consistently since then, offering services. And again, it was verified before we came up here that in fact, no one did contact them. Again, I would have expected that the Department of Health Services would have contacted them to let them know. Obviously, we want to safeguard her safety and the community safety, because frankly, when she's released based upon some of the evidence that came out previous hearings, we have concerns about the safety of the community as well.
Just for clarity, she was at that group home for, what was the duration? Was it September?
The judge, the final plan of placement was signed September 17th, I believe. And I'd like to take credit for knowing that. But again, Attorney Nicolai is the one who put together the timeline, and that was the time. So when she got to the facility, we were not sure, but that's when the court signed the order for the placement.
Looking back, do you wish that there would have been more communication between your office and a group home like that? Is that something maybe moving forward we would like to see?
Again, we're not, once the conditional release plan was signed, we really are not involved in the case. The people, DHS, they're the ones whose custody she has been given to. They would be the ones that would control that day to day. And again, I don't know what that communication is. It could have been a daily communication. It could have been a weekly communication. I'm not sure. You'd have to reach out to DHS to see exactly what that consists of. Again, our goal in our position is to hold people accountable. Certainly that's why Attorney Nicolai had advocated for the conditional release not to be granted, because that was part of the accountability and keeping our community safe.
Do you feel like there should be some mechanism to notify families in a case like this?
Absolutely. I've reached out to already some legislative personnel to see if we can't address that issue. I think that's wrong.
Any other final questions?
Thank you very much.
The district attorney there in Waukesha County confirming that they don't know yet, in terms of the Waukesha County officials, who that adult was with the 23-year-old defendant, but that that's someone who would be investigated at this point for helping her in this escape.
Yeah, lots ahead here. You've got the situation in Dane County, that's Madison, where she was at that halfway house. Did she, was it a felony for her to cut the bracelet? Will she be criminally prosecuted there? Waukesha County clearly wants the Department of Health Services now to file a motion to revoke that conditional release and put her back at that hospital, which is just north of Milwaukee. A lot of places. She's still in Cook County, Illinois, in Chicago, so they're going to extradite eventually.
The governors have to talk about that because it's state to state, but it sounds like there's not going to be any issue there. But still a lot of questions when you had so many people saying she would be fine in this.
And who helped her? That's the big question still.
No discussion of the case, just scheduling purposes. Is that what all of those conversations have been for? Is scheduling purposes? Has there been ever any ex parte communication concerning any of the factual matters concerning this case? Scheduling. All right. Anything else?
I do have a follow-up question. Besides yourself, were there other people from the defense team that were on the call that day that you're aware of? And who was that? Okay. No further questions.
And for the record, I did say 101 Poplar, it's 201. But I remember I misidentified in that call. But I think the intent to urge settlement discussions is what the court was getting at, to encourage settlement discussions. And everyone in Shelby County knows about 201 Poplar, and that's just was an easy way to make reference. But I did say 101. So, all right. Anything else with this witness?
No, Your Honor.
Step down.
Your Honor, in this case, we are asking that the court recuse itself. This is a death penalty case, which has a heightened standard of due process. The telephone call that the court, in the telephone conference, which the court disqualified Mr. Evans, the court made several comments. One of the things that the court said was that it had spoken with Jennifer Nichols, and that Jennifer Nichols had raised concerns about the conflict with Luke Evans. The fact that that is more than simply scheduling, Your Honor. She raised concerns that that Luke Evans had a conflict. She also mentioned the fact, she expressed that she was concerned about settlement negotiations and the appearance of a conflict. And Your Honor, those things that were discussed are more than simply scheduling issue. They are ex parte communications that the court had with the state. And that is, it's not allowed under the rules. And it would give, I mean, the court disqualified Mr. Evans based on the fact that it would erode the public's confidence in the judicial system. And because the judge, the court in this case, had extrajudicial communication with the state when the defense was not present, then that in and of itself, Your Honor, would be a reason to disqualify the court. The second reason would be that the court said, based on what, just the very statement, based on what I have been, based on new developments in the case, and what the court has been led to believe occurred, like I said 3 months ago, if I were the defense, I'd be beating down the door at 101 Poplar to see if I can get something reached to resolve the case. And Your Honor, based on that statement, that the fact that it's not simply encouraging the parties to negotiate and settlement discussions, it is specifically giving an opinion that if the court were the defense attorney, and it also says based on what the court has been led to believe. So therefore, the court has some information. Based on that information, if the court were a defense attorney in this case, the court would certainly think that it's appropriate and necessary for Mr. Adams to be working out a plea deal in this case. And that's clear to the public. And the standard in this case, the standard that the court uses, is not what does the court know or what the court believes, but when you're looking specifically at the standard regarding a court's recusal, then the standard is what would an ordinary person in the public believe after seeing that statement. And it's clear that an ordinary person in the public is going to believe if the judge has said, you better be beating on the door of the prosecutor's office, and it's clear that the court believes that it is necessary, prudent, and probably...
As an officer of the court, how many times have I told you that it was not too early for negotiations? I told every single attorney in this room, they were present. Every time we've been in court, to my knowledge, I have tried to encourage the parties to negotiate towards some type of reasonable settlement so that this case may be put to rest. Will you agree as an officer of the court that I have done that?
Certainly, yes. But when the court phrased it that way, it put a chill onto the defense team because it came across as though the court had made up its mind. The court thinks Mr. Adams is guilty, and the court thinks he should be working out a plea deal. And the second issue that I did raise in the motion for recusal is that the court has continually brought up the fact that there's not going to be a continuance of the April. Nobody at this point had asked for a continuance. Recently, I think we filed a motion that was ruled on in November, but nobody had asked for a continuance, and that also comes across that the court has already decided that issue as to whether or not it would grant a continuance, and that there's not going to be any reason for an exception. And again, having prejudged an issue, Your Honor, and expressed an opinion on that issue, then I think that's a second reason that the court should recuse itself. So there's three reasons, and when you look at the law and what the law supports in a case like this, that because the court has had ex parte communication, and even though it may have been slight, it's still the state expressed their concern about the conflict of interest issue, and they did more than just simply say, we need a hearing. They said, we're concerned and we are
as soon as they add an and we are especially concerned about trying to enter into plea negotiations. That gives their opinion. They have communicated something to the court besides simply saying that they want a date to hear something on the record, or they need a date for a hearing. And because of that, Your Honor, we say that under the law, and the law is clear, that under the law in this case, and there's a heightened due process responsibility when a person is facing the death penalty. And there's case law that says that too, that in a death penalty case, they have a heightened due process responsibility to have a court that is unbiased and that appears unbiased. And so based on those three reasons, Your Honor, we're asking that the court recuse itself.
I'll be brief, Your Honor, to address Ms. Thompson's concerns. One, about any extrajudicial statements that were made. Your Honor, I've been on the case over 2 years. From the beginning, you not only encouraged us to call you, there was a scheduling issue. You actually explained that you're out of your office quite frequently, being a circuit judge, and that everyone has your cell number. You gave it to us in chambers, all of the attorneys. When I realized that I needed a telecom or something perhaps set on this date, I did pick up the telephone. I called you. I asked if I could schedule a teleconference. And I don't know in what world Ms. Thompson practices in, but I've never set a hearing with the judge without telling him or her what the hearing was to be about. And I said, I have a concern about Mr. Evans' representation of Zach Adams. That's as far as it got. And you correctly.
Would you agree that the total time of that telephone conference was less than 5 minutes?
I disagree. I think it was less than 2 minutes.
Okay. And part of that was dead time because I told you I was in a restaurant.
Yes, you went out to the car.
And total sum and substance, less than 2 minutes.
Yes, sir. Not only have I never, ever discussed the substance of the case against Zach Adams with Your Honor, I've never made statements about the case against Dylan Adams, nor Jason Autry, to Your Honor. Ms. Thompson made statements that you must have some information about what other defendants would say or wouldn't say. I can't speak to that because I haven't, and no one on the prosecution team has had those discussions with you. There were no extrajudicial statements made by me to you. There was zero discussion about the substance of anything other than we had received a notice of appearance representation from Luke Evans. I contacted the defense, all of them, including Luke Evans, explained my concerns. We've attached the email string to a filing this morning between myself and the defense, Luke Evans' response, and then Paul Hagerman's response there too. When that didn't work out, I called for a teleconference, which is what Your Honor has instructed all counsel to do. And based on the statements you've made from the bench this morning, others have apparently taken advantage of that much more so than the state. I needed to voice the very real concern that we had about a conflict. And I won't get into that now because I know we're talking about recusal. I think the second issue that was negotiations. I've been on the case a little more than 2 years. From day one, every single interaction I have had with you, with defense counsel present, with you on the bench, with you in chambers, or a teleconference, with every defense lawyer, you have made the same type of statement. And the interesting part, though she is choosing to gear it towards some predetermination of guilt on your part, frankly, I took it as an admonishment to the state that we must engage in settlement negotiations if that was possible, because you wanted to keep things moving. You have never aimed those comments at one party in particular. You advised all of us to talk. And in terms of coming to 201 Poplar, that's customary. We just all happen to be spread out. And that comment that was made about 201 Poplar, and frankly, it's been made more than once, I think means nothing other than get together and talk.
At one time, I think I said, it's not too early to negotiate. Did I not?
Those are your exact words, but I believe you said them more than once.
Okay.
And this, I think Ms. Thompson made reference to 3 months ago, you're saying something. Your Honor, this has been going on for over 2 years that I've been on the case. And I can't speak to what you said before that, but I know what has taken place since November, December of 2014. And I don't have anything further.
It's her third issue, continuance. You want to address anything on that? The statement of the court to stand firm in a trial date.
Well, I'm sorry I didn't address it because I frankly thought that's what your job was. You set this trial date months and months and months ago. And you, just like you've always encouraged us to engage in discussion, if appropriate, you've also said we're going to trial. And we all have.
Do you recall these exact words? And unfortunately, I was pointing my finger when I said it, that the court will try someone on April 3rd. At that time, there was no election, but I think those were my exact words, that the court fully intended to try someone on April 3rd.
You were so adamant about that, that the state felt that we needed to advise one of the defendants in particular and advise the court that that defendant was not going to be the first one that we tried. And that left 2. We felt.
Well, I think I stated that in open court.
You did.
Because the attorneys,
You were pointing at me.
Scholl and Mr. Parrish, came on board later than the other attorneys. And I think I said that that theirs would be not before the second day.
Right. Now that was said from the bench, but it's also been said on every telecon and in chambers. Until today, we have all met as a group, every single court appearance that I've come in the last 2 years in chambers. And you've made the same statements.
Anything else?
Yes, Your Honor. Along with my motion, I filed 2 other items as attachments, exhibits. Exhibit A was the ethics inquiry email between Mr. Evans.
I've seen it. It's attached to your pleadings.
And I'd like to make that an exhibit to today's.
I don't know that we need to exhibit. It's part of the record because it's attached to your pleading.
Well, I'm thinking in terms of an appeal, Your Honor. I think in terms of the appeal, I'd like that and the waiver to be made exhibits to this hearing today.
It's already in the record. If there's an appeal, the pleadings will go up with the attachments.
That's true. In order to have separate exhibits, it would be duplicitous and more or less carrying the coals to Newcastle, wherever that expression started.
And the other thing that's happened is, Ms. Nichols has been basically testifying about things that occurred in the telephone call, but she's not done that formally. And she's been arguing facts that aren't in the record. And I would like to point that out, and I object to those coming in because they've not been made an official part of the record, and she has not testified to them.
She's an officer of the court, as are you. Okay? All right. Short recess. I'll make findings on the motion to recuse.
All right.
He doesn't know about the little monitor stuff.
Yes, he does. Yes, he does.
Court been in recess.
Smoking gun. to say first and foremost, to put a case on someone else unless there is a true conflict, which there is not. The defendant, through counsel, Ms. Thompson, filed a motion pursuant to Rule 10B of the Tennessee Supreme Court 101 for the court to be recused in this case. And in her memorandum set forth grounds. I want to dispel some of those. First of all, I think it's very clear at this point that the telephonic conversation on that Friday prior to the conference call was of short duration with absolutely no discussion concerning the merits of this case. As I've done on other occasions, I encouraged counsel to see if they could work the matter out. Said, if you can't, you call my office, we'll do a conference call. It was my intention that that would be done quickly because we've got a trial date approaching, and I wanted to resolve the issue as soon as possible. At this particular time, I'm not going to get into the disqualification of Mr. Evans. I will take that up in a few moments on the defendant's motion. But there was no ex parte conversation. That didn't occur. Any conversation was towards scheduling, which is expressly allowed under the Tennessee Supreme Court rules, judicial conduct. As far as the matter on negotiations, as has been pointed out from day one, I've negotiated the parties, or I've tried to encourage negotiation between the parties. That was confirmed by the attorneys that at one time I actually said it's not too early for the parties to start negotiations. I think any good trial judge is not being responsible if they don't ask the parties in good faith to negotiate. The system without negotiated plea agreements would absolutely break down. So that's part of the process. And yes, you're right, I have encouraged it. I've encouraged it a multitude of times. I've attempted to encourage it firmly, but not coercively. I want to make another thing clear concerning me speaking of negotiations. I did get a call from one of the attorneys. They advised that they would not be needing a trial date. There were no discussions of the merits whatsoever. Is that correct, Mr. Shaw?
That was from me, Your Honor.
Yes.
I gave you 2 phone calls, one of which was to ask about what the procedure would to get a plea agreement in Your Honor's court for approval. And then I told you I would notify Your Honor if we had felt that we were not going to be.
I have never discussed whatsoever your client's case, have I?
We have not, Judge. I also told you on my second phone call.
That I would not be needing, that you would not be needing a trial date.
Second phone call, I told Your Honor we would not be a trial.
So that was probably what triggered what I said, that given recent developments in the case, that I would further ask the court, the parties to negotiate.
Judge, and I did that with the state's knowledge.
And then as I said, I don't see the negotiations that the court asked the parties to engage in negotiations as showing any bias whatsoever of the court. And I don't have any other attorneys in here in other cases, but I've got police agents that will tell you it's not unusual in this particular case, that it's frequently done, that I've asked the parties to engage in negotiations. It's no comment on the presumption of innocence that the defendant has. It's simply that the parties need to have some reasonable dialogue concerning their case. And concerning the fact that the court has said that I don't intend to continue the case, I guess that should be modified somewhat to indicate that I don't intend to continue the case absent good cause shown. And for good cause shown, it might be the unavailability of a material witness, it might be sickness or something on behalf of an attorney, but what I've tried to encourage the parties to fully understand that I don't want to get to the trial date and then have someone say, Judge, we're not prepared to go forward. Because it's been over 2 years. I think I could ready myself to try the Nuremberg trials in 2 years. So that's what I meant. Good cause shown, the court might have to, but it's firmly my intention to go forward as scheduled. So your motion for recusal is hereby overruled by the court. You want to proceed on your second motion?
Yes.
All right. It's a motion to set aside order disqualifying Luke Evans as attorney of record for Zach Adams. And I want to make a preliminary statement concerning that at this time. I have never, to my knowledge, set eyes on Luke Evans. I'm assuming this might be him in the courtroom, but I don't know. And I think he will confirm that. I will say that anything that I know about Luke Evans' involvement in this case was gleaned from a public record. I was preparing to hear a motion for injunction to enforce an immunity agreement that was filed in the Chancery Court of Decatur County. Frequently, I interchanged with the Chancellor, and she was fairly new at the time, and I was prepared to hear it. And then the untimely death of Mr. Shane Austin rendered the case moot. But is that not correct? We've never met, to my knowledge, have we?
That's correct, Your Honor. I think we had a teleconference in that case.
We did in that one. I didn't even remember
yeah,
that.
We had with Scott Sutherland, with the Attorney General's office, myself, and yourself. It was a scheduling conference regarding setting a hearing out prior to Mr. Austin.
And then upon his demise, it was moot.
That's correct.
Okay, thank you. All right, proceed with your motion, please.
Yes, Your Honor. I would like to call Luke Evans to testify.
Okay, come around, sir. I want you to raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Would you state your name for the record, please?
Luke A. Evans.
Okay. And how are you employed?
Attorney.
Okay. And who do you practice with?
I'm a law partner at the law firm of Bullet Fly, Queen Evans, Murfreesboro, Tennessee.
Okay. And can you explain to the court how it is that you came to be involved in the representation of Zachary Adams?
Yes, I was contacted by you and asked if I would be both willing and able to engage on behalf of Mr. Adams. In response to that inquiry, my first statement was that I needed to check with the BPR because I had previously represented Shane Austin.
Okay. And did you in fact check with the Board of Professional Responsibility?
I did. I contacted them immediately after speaking with you on November 23rd, 2016. I spoke with Stephen Christopher that afternoon in detail about the issues related to any potential conflict that might exist or ultimately might.
We use the acronym BPR, Board of Professional Responsibility. We've got a lot of people that are non-lawyers.
Sorry about that. So I called the Tennessee Board of Professional Responsibility and ran it by Mr. Christopher in detail.
Just what details did you tell him? I mean, what facts did you make clear to him when he made the decision that, or when he advised you that there would not be a conflict?
On that date, I alerted Mr. Christopher that I had previously represented Mr. Austin, who had not been indicted in the case, but was considered at the time a person of interest in the investigation. I let Mr. Christopher know that I had filed a civil suit and litigated the issue of enforcement of the community agreement in the Chancery Court in Gator County, and that there was a proffer attended where for those who don't know what a proffer is, that where myself, Mr. Austin, met with several agents from the TBI one evening, and had a discussion with them, as well as I had some interactions with Ms. Beth Boswell, who was the attorney at the time handling the case. Had some discussions with her in negotiating an immunity agreement. I then let Mr. Christopher know that after all that had transpired and we were litigating in Chancery Court, that Mr. Austin had unfortunately taken his own life. He was now deceased, and that I had been contacted by the defense team for Zach Adams with an inquiry as to whether or not I could possibly be one of his attorneys.
And what did you advise the board as to Zach Adams and what your role would be and how his case related to Shane Austin?
Well, what I advised the board and what I had been, information I had received from the defense team was that essentially there would be a consistent defense theory at play in front.
And what does that mean, consistent defense theory?
Essentially, from what I understood from speaking with you initially, that your argument on behalf of Zach, and therefore Zach's argument was that not only was he innocent of this, they were all innocent of this.
Okay.
Including Shane Austin.
Okay. And so then, did you relate to them any additional information?
Not that I
Like
recall.
whether Zach had been charged or?
Just saying.
Did you relate to them any information about the status this case was in?
I did let them know that that was the case. That was currently pending with Zach Adams. I'll know who the other co-defendants were in the case, I believe, when I was discussing.
Okay. And then based on that, what did you do next?
Well, I received an informal opinion from the BPR, which was provided to the court. That day, I just received it verbally from Stephen Christopher. The opinion was that there was a conflict of interest. My understanding of his opinion was that essentially Mr. Austin was.
Let me say, the parties furnished, or they sent some emails both sides discussion of this issue and the opinions, which were forwarded to me by the staff attorney. I don't actually get emails directly from any of you. They either come to Sherry or they come to Susan Jones. But I was made aware of the email correspondence. So I didn't engage in the ex parte. I viewed emails that had been exchanged between the parties.
And I'd like to pass up to you a paper. And do you recognize what that is?
I do. This was this is a copy of the email inquiry that I ended up asking Ms. Laura Chastain to send me when I contacted them on January 18th. But it was generated, my understanding, by Mr. Christopher on November 23rd in response to my call.
Okay, so will you tell me then what happened? He gave you an opinion.
Yes.
And after he gave you an opinion, what did you do next?
I immediately contacted you back and let you know that that I was cleared from the board's perspective. There was no conflict of interest, no issue related to my being able to engage in the representation of Mr. Adams. And so from that perspective, that I was
you understand that there's a difference between having represented someone in a criminal action versus having represented them in a civil action?
Yes, and that's one of the things that Mr. Christopher made clear when I spoke with him, was that essentially, it would almost be.
I would object to what Mr. Christopher may have said in the children's hall between this witness, and we weren't present for it.
He says hearsay, all right?
Right, but
We've got the written email, which the court will consider, but what the prior conversation, he can say, which he already has, we've had it, I disclosed things, he said there was no conflict. We've already filed that.
Okay. But what do you understand after doing research and looking at the information is the difference between having represented someone in a criminal matter versus a civil matter?
Well, essentially my understanding, upon review of the rules and what I considered before engaging in this case was, could I ever be in a position to take it, in representing Mr. Adams, that would be materially adverse to Shane Austin, my former client. Upon my review of the rules, and under current understanding of everything I've reviewed, the state is essentially in a spot where they cannot take any further adverse action against Shane Austin in a criminal matter because he is deceased. Unfortunately, he's deceased, and you can't charge somebody who's deceased with a crime. So, my understanding of it from that perspective was that would be in play. There's no current concern about a conflict that's related to Mr. Austin. I also understood it based on the opinion that was rendered back tonight. Disclose any confidential information I gleaned through my representation of Shane Austin. And based on everything I reviewed and understood, my current representation of Zach Adams would not require me to do that.
Okay. And was it your understanding, what if at some point the defense team decided to go with a different theory that perhaps implicated Shane Austin? Would that have affected your ability to represent Zach Adams in this case?
I don't believe so, based on everything I looked at again, because the test is not, the test is based on review of the rule, whether or not it would adversely affect the former client. And again, even if you, theoretically, even if Mr. Adams took that position, it still would not have been the rules of professional conduct because it wouldn't have an adverse effect on Mr. Austin.
Okay. And did you also talk with Zach Adams in this case?
I did, absolutely.
And did you discuss with him your representation and the fact you had represented Shane Austin?
Absolutely, I discussed that with Mr. Adams, and I discussed that with you as well. And the sole purpose of that was almost, from my perspective, is a belts and suspenders type of ideal to ensure that there was a conflict waiver signed by Mr. Adams. I wanted to, on top of, even though I don't think it was required, based on my understanding of the rules of ethics, I wanted to make sure that I had it. I wanted to make sure that he understood it, and that there was no issue with that. So yes, that discussion.
And what I have put before you, do you recognize that?
I do.
What is that?
That is the conflict waiver that you provided me that was signed by Mr. Adams.
Okay, I'd like to make those two things exhibit.
They're attached to your pleadings, that is exhibit B to your pleadings.
I guess my fear is, Your Honor, I'm aware of another case that went up on appeal, and the court said because it wasn't made an exhibit to the testimony, that something that's in the pleading doesn't meet the standard.
But that's in the pleadings up. We'll just sit the pleadings up.
The pleadings will be sent.
I'm just trying to cover all the bases. Okay, so after you had received the opinion from the Board of Professional Responsibility, what did you do next?
Your opinion is exhibit A. It's attached, okay?
Yes, Your Honor.
After I received the opinion from the Board of Professional Responsibility, and informed you of that fact, I waited to hear back because it was my understanding that you and Mr. Simmons were going to approach the court regarding employment in this case.
Okay. And at some point, then, when did you begin work on the case?
December 29th, if I recall correctly, approximately December 29th, December 30th.
And when did you file your notice of appearance in this matter?
I'd have to see the date on the notice of appearance, but I would say maybe January 7th rings a bell, but I can be sure. Whatever date stamp filed on it, or whenever the email was sent.
Okay. And what happened after that?
Well, immediately upon being notified by you, Mr. Simmons, that I've been appointed subject to AOC approval by the judge, I began working because I knew that there was a trial date looming in April. Sent the notice of appearance out. We attended a discovery conference with Mr. Christensen and Mr. Hagerman and several members of the TBI on the 11th and 12th of January. Worked through that. Sometime after that, I received a email from Ms. Nichols, Ms. Jennifer Nichols, saying that she had a concern about a potential conflict.
And when you received the email from her, what did you do next?
I responded to Ms. Nichols' email, probably within a few minutes or a few hours, something to that effect, but on the same day, let her know that I had taken steps to ensure that there was no conflict of interest, that there was no issue, and that my representation of Mr. Adams didn't in any way offend the rule of professional conduct.
Then, as far as you know, what happened next is regarding you representing Mr. Adams?
I believe I received another email from Ms. Nichols. At that point in time, it said that, again, I think she stressed her overall concern, saying that she believed there was a conflict, not her exact words. And at that point in time, I contacted the BPR again. I think that was January 18th. I contacted the Board of Professional Responsibility. On that day, I spoke initially with Ms. Laura Chastain, who forwarded me the inquiry on December 3rd, and then spoke again with Mr. Stephen Christopher. During that conversation, I let Mr. Christopher know that the concerns that had been raised by the state, I think I even read it in our conversation, email.
And I'm gonna object.
Oh, it's what you did, right? You're trying to.
He's also saying what the party responded.
He can say what he did, but
Well, just tell us what you did.
I don't see the list he could, we can't know what the response is.
What did you do?
I read the email that Ms. Nichols had sent me.
So you made her concerns known to the Board of Professional Responsibility.
I did.
What happened after that?
The email that was forwarded to me by the BPR showing that no conflict existed.
And what was your next interaction with the prosecutors in this case?
The next interaction I had is when we left this discovery conference, we had been discussing several issues of deficient discovery or missing discovery, or that we couldn't put our hand, at least discovery that the defense is not going to get made aware of in some cases, what was provided. A list was then done by your paralegal who was present in the meeting and sent to the state, and I was again concerned about the upcoming trial date. Emailed out to Paul Hagerman to say two things. One was, hey, we just want to check status on the discovery. Where are we on that? The second part of it was to inquire about any proper statements that they received from Jason Autry.
I'm not objecting at this point. I don't see the really purpose of this hearing is whether or not there's a conflict.
Right.
And we are well beyond that. I sat silent for a minute to see where we were going, but I think any conversations that we now have crossed over.
Concerning discovery, anything else is irrelevant.
Well, but I'm just trying to outline the facts as I have them in my motion as to what led up to us having the telephone conference and him being disqualified. So what I was wanting him to, get to is just what Paul Hagerman had said to him and then what he did from there, how we came to have the telephone conference.
Your Honor, the discovery issues has nothing to do with how we came to have a telephone conference. And actually, those emails are also attached to the state's filing this morning so that Your Honor would have benefit of those. But I still say it's hearsay and it's not relevant to whether.
I don't see relevance.
Okay, so then let's just go to the telephone conference. You were a party to the telephone conference?
I was.
And in that conference, was there anything, any new issues raised or new facts raised in the conference that would justify you being conflicted out?
I'm going to object, Your Honor, since it's not his opinion about whether he's, purpose of the phone call was
I didn't let either side argue anything that day. I said that upon further reflection, I reached a conclusion that he would no longer ethically be part of the representation. That just based upon facts that I knew essentially from his prior representation concerning the fact that for all intents and purposes, he was representing a fourth co-defendant.
Okay, so.
But I think both parties will agree. I didn't ask the state for anything further, nor you further.
Yes, that's the point that I was trying to put in. And so then no further questions, Your Honor.
All right. Cross-examination.
Mr. Adams, I was trying to write down the items that you said that you provided to BPR on the call, and I wrote down, she advised him that she had previously represented Shane Austin, correct? You said yes.
Yes.
That you had advised him that you had engaged in a proper and immunity discussions.
Yes.
And that would have been with both the assistant district attorney handling the case as well as special agents with Tennessee Bureau of Investigation. Now, that any discussions with Beth Cosmo, present at the actual process?
She was not present.
Present at the actual process, a number of the special agents. Correct?
Yes. Yes.
Did you advise them that you had filed a chancery action?
Correct.
And that was upon Beth Boswell and some accountants determination that your client at the time, Shane Austin, had not been completely forthright and honest.
Can you repeat that? I'm sorry.
You filed a chancery action to enforce the immunity agreement, and Hanson McAdams and Beth Boswell withdrew their offer of immunity.
Correct.
They withdrew that because in their estimation, as is evidenced by correspondence from them to you, that they did not believe that he was completely honest and upfront.
That's correct.
Right. And you told the board that you had discussed this case with Beth Boswell.
That's correct.
And you told the board apparently that it was a death penalty case.
That's correct.
You did not, however, Ms. Thompson asked you, was there anything else? You told her anything else, you said no. So you didn't tell them that Shane Austin said that Zach Adams told him that Zach Adams, killed Holly Bobo. That wasn't in the list of things, correct?
Back up again. You're going to have to repeat the question.
All right. I will back up. 2 questions. Ms. Thompson specifically asked you whether the list of items that I just read were the sum total of what you discussed, what you provided to BPR. You said it was.
I don't recall giving that answer as a conclusive answer.
Well, yes or no, you said yes, so you're saying now that's not conclusive?
I'm saying that.
Mara, I didn't ask that question. I didn't say that all you told them.
Well, she did.
Is that all you told them?
No.
Okay, so.
You got, it depends on which day. I talked with them if there is one of those on the 23rd. I spoke with them again on January 8th. So
In any conversation with BPR, did you advise them that your client, Shane Austin, told 3 special agents with the Tennessee Bureau of Investigation that Zach Adams
killed Holly Bobo.
Not those words, I think.
Okay, thank you. Did you tell? No, that's enough.
He's allowed to explain. Answer yes or no, and then if you wish to make explanation.
What I told him was that during my representation of Shane Austin, that he did in fact commit fraud, where he made statements that implicated Zach Adams. Absolutely.
Okay, well, that's what a proffered immunity, that wasn't my question. So my question was, did you actually tell the Board of Professional Responsibility that your client, Shane Austin, said Zach Adams killed Holly Bobo?
I wouldn't have said that.
Okay. You wouldn't recall that?
I said I would not have said that because I don't recall my client Shane Austin saying that during the proffer round.
And you didn't, I assume, tell them that your client, Shane Austin, told you that Zach Adams said he put her in the river next to a rock that had an orange T painted on it.
I wouldn't have specifically said that, no. I didn't, no.
Your Honor, I object. Ms. Nichols is mischaracterizing what was said in the proffer. Shane Austin did not say.
She's allowed to ask the questions if you want to re-examine.
She's mischaracterizing what was said in the proffer for the court. That's not what was said in the proffer.
Go ahead.
Your Honor, I'm reading from a report and have spoken to the agents and have spoken to Ms. Boswell. I assure Your Honor, now, as in every other time I've appeared before you, I don't misrepresent what I believe to be the truth based on the evidence in front of me.
All right.
This is important, and I want to know what the board had in front of them when they issued or confirmed the defenses were similar. So it seems highly unlikely that Mr. Evans may actually advise him of this.
He didn't say similar, he said consistent.
Consistent.
Correct.
So that's no, you said you didn't tell him that.
Not those exact words, because.
Okay, any other answer?
Your Honor, I may have the opportunity to complete my answer.
Go ahead.
I wouldn't have told them specifics, number one, because I didn't have the benefit of that report or the specific recollection that you're able to recall reading the report that I didn't have the benefit of when I got the meeting.
So if you didn't have the benefit of the report, you have the benefit, you are the person who, in the course of this proffer, assisted the special agents in getting a handwritten note from Shane Austin that implicated Zach Adams. Surely you have recollection of that.
I do.
And did you list for the board the 5 statements that Shane Austin wrote on his handwritten note?
No, because I didn't have it before me, but if you would have emailed it to me, I would have been glad to discuss it with the board at any given moment.
And you'd agree with Mr. Evans that we, the state would have no way of knowing that you were trying to have yourself put on this case?
No, I mean, when you emailed me on the 18th or the 16th, if there's anything you wanted me to let them know, I would have been glad to do that.
So Shane Austin told you that Zach said, I will make you disappear like I did that girl. That's what he wrote, right? In your presence.
Can you tell me?
That's what he wrote in your presence during the course of the process.
Can I take a look at that?
No. I mean, I'll pass it in a minute. I want to see what you remember. Okay. Do you recall that he said that he wrote, I had her chained up in the back and called Shane to, please excuse me, Your Honor, fuck her. Remember that one?
What I recall.
Wait a second. I don't want any disturbance out there.
No, I don't recall that being said.
Do you recall Shane Austin writing in your presence and you providing it to TBI? You have to gut them so they won't float.
that interaction, ma'am.
And I'm gonna ask you to answer yes or no and then explain
No, I
as
don't
the
recall that specifically, no. Because that's not what I said.
Do you recall Shane Austin writing in his own handwriting that Zach said, I put her by the teeth in the river. They'll never find her there.
I do recall that, yes.
Do you recall Shane saying, Zach said, no body, no crime?
I do recall that.
So those items, the ones that you recall today and the ones that you don't, were not provided to the BPR when you spoke to them, correct?
Not specifically in those words. What was provided to the BPR was me running through factual scenarios like, if my former client absolutely said that the current client had admitted to doing it in certain times, in certain places, would that in any way affect my ability to engage in representation of the current client if my former client was now deceased? I think that pretty well covers all those statements, but it would have to be accurate reading of those statements.
And you would agree that the email that you received for BPR says the caller confirmed. You're the caller, right?
Yes, ma'am.
So Luke Evans confirmed to the Board of Professional Responsibility that the legal and factual positions of the former client and prospective client with regard to criminal allegations are consistent.
Correct.
So despite the fact that you were present for this proffer, and despite the fact that you were present when your client at that time wrote those 5 things about the person you now want to represent, you confirmed for BPR that that was consistent?
Absolutely. Their positions from what I've been informed from the defense team are absolutely consistent.
You were present here at the telephone, of course, when the judge disqualified you from continuing to represent Zach Adams, correct?
Yes.
You heard him make statements, of course, about the appearance of impropriety or conflict of interest with respect to the public and the public's, in the family, and the public's confidence in the judicial system.
Yes.
And would it surprise you to know that this family and these friends of Holly Bobo would have a significant problem with you representing Shane Austin and then now representing Zach Adams? Would that surprise you? Because that's the public.
Well, it wouldn't surprise me. I can't begin to imagine what those ladies and gentlemen have endured. That wouldn't surprise me, but that's not the legal standard. Appearance of impropriety is not the legal standard.
And I appreciate you trying to educate us, but that was my question.
Okay, well,
You understand my question?
I answered it. You need me to explain it?
No?
Okay.
You answered affirmative. Do you agree with me or you wouldn't be surprised?
But I said, look, I can't imagine this. I can't begin to imagine this.
Have you ever had that in that case? Ever tried one? One. Sorry, what'd you say? Have you ever tried one?
I haven't said anything yet. I previously handled a death penalty case that.
Sorry, that wasn't my question. Have you ever tried a death penalty case?
No, ma'am.
Despite never having tried a death penalty case, you're aware of the scrutiny placed on those cases in the event of conviction down the road. Correct?
Sure.
You've read about that, I assume. Since you have tried them.
And I've tried multiple homicides, and I'm aware of the heightened standard, and I've handled other death penalty cases.
But haven't tried one.
Luckily, they took that off the table before I went to trial.
You saw this waiver
I did.
in this Thompson attached to our pleading. You recognize how it's going to go handwriting.
I did.
And you read it.
I have.
And it's your position, you're going to sit here under oath as an attorney
and tell the court that you should stay on this case despite the fact that you guys got the defendant, Zachary Adams, to sign a waiver saying that there might be conflicts in the future. We don't know about them yet, but that's okay.
I don't understand your question.
Look, you told us that in part, you based the fact that you didn't think there was conflict on the waiver and on the BPR opinion. Is that a yes?
Yeah.
And so this waiver says, there may also be actual conflicts at some point in the future. I have discussed this matter with Jennifer Thompson and am willing to waive any conflicts.
Okay.
So in other words, what's his educational background? Zach Adams.
I don't know about that.
Right. And that might be an important thing to know when you obtain this kind of a waiver from somebody, right?
Well, I think we take the waivers.
Now, I'm just asking because you said you handle so many cases.
Sure.
And so if a person doesn't understand what they are being asked to sign or what they are waiving away, that would be a concern, wouldn't it?
No, absolutely. If it was in fact the case that the person didn't understand, sure. That would be a problem.
How many capital post-convictions have you done?
One.
Do you understand that this waiver, Mr. Adams, agreeing that he's waiving things in the future that he doesn't even know about, would not stand over the course of time when looked at in the post-conviction arena, separate and apart from your BPR clearance to proceed? This is a different issue.
Are you giving me a legal opinion or are you asking me a question?
That's the question.
You're gonna have to restate it. I didn't hear your question.
Do you understand, given your vast experience, that this kind of waiver would not stand the test when it's looked at later on if he's convicted?
I don't understand that, because I don't know that you can understand it either. We're not the courts, we're not in the future. So
you don't know the answer to that question?
no, ma'am.
What number, Trevor?
I need to ask you, I've got some documents back there. Is that proper that you've been referring to? I either need that in exhibit or I need it attached to pleadings.
I'll get you a clean copy of this.
Okay.
It's attached to it. I have something circled on mine. I'm gonna get a clean copy of it. And you should have it, but I wouldn't want you to have to sift through the hard drive because it's IR.
Let's just file it as an exhibit.
Okay.
One.
One number, Joe. One that what the question? In the board opinion that you shared with us, it actually says that that opinion is not binding on any court, correct?
Absolutely.
Or anyone else, for that matter.
That's correct.
It doesn't afford you protection. Either.
Nope, it does not.
Your Honor, I've got the hour, but I just want to get a clean copy that's not circled. But I'll go ahead and file it, maybe I'll substitute it, show you the pencils, so I don't have to circle.
I think we got it. We've been here.
And it has an attachment.
Right here, hand that to her. Maybe that's,
That's the attachment to the proffer.
okay.
The actual proffer that Ms. Thompson is indicating.
Well, the attachment was what you were reading from.
Actually, I was reading from both, Your Honor.
All right,
Let me pass forward.
I've got it. Let's,
I don't think that's what she has. That's not what. No, sir. That immunity agreement we discussed, I'm passing forward. That's what I was reading from the part.
it's got some markings. It makes no difference to the court. The handwritten was attached to to this. All right. Then that'll be exhibit 1.
Nothing for you, sir.
Yes, I'd like to see exhibit 1 if I could, please. Now, would you agree with me that saying somebody killed Holly Bobo and saying somebody said they killed Holly Bobo are two different things?
They are.
Okay. Your Honor, I'm going to object to relevance to whether.
No, let her go. Let her go.
And so when Shane Austin went in to give his proffer, he specifically told the TBI that he never believed that Zach Adams had actually done those things. He was telling the TBI what he had heard Zach Adams say before.
Yes, that's correct.
And the statement, if you look at this IR report, the statement that he made about having Holly chained up, Shane Austin said that Zach Adams said that in a bar. Isn't that right? And Double B's or Johnny's?
I'd have to look at the report to see what it says.
I'll just pass it to you and refresh your memory.
That's correct.
I just want to refresh your memory on the whole thing, and then I can ask you more questions about it.
Your Honor, can we have a sidebar conference with the county judge?
Yes. Let's go back there. I'll have the court reporter join us.
All rise. Court may recess.
seated. Mr. Evans, let me say that you cannot testify to anything that would be considered client privilege, client attorney privilege.
Absolutely.
You understand that? Okay.
And I want to say for the record, at no time during my examination have I testified to anything.
Sometimes the way the questions are couched might raise concerns, okay? So listen very carefully, because you can't disclose communications between you and Mr. Austin. Okay.
Now, the state had asked you about a quote that Shane Austin presented in the proffer session. And it was the one where Shane said that Zach claimed to have Holly Bobo chained up out back and called Shane to fuck her. Isn't it true that that statement was made by Zach Adams in a bar to unknown people?
I'm going to object to hearsay, speculation. He can't know when it was made.
No.
I mean, if his client makes certain representations about when it was
That would violate privilege.
I'm sorry. Isn't it accurate that that's something that Shane Austin said in the proffer? That he heard Zach Adams say in a bar to unknown people, he had Holly chained up at back and called Shane to fuck her.
According to what's said in the proffer, in the IR, that's what's written.
And according to the IR, when Shane said that no body, no crime, at that time, that was not something that Shane Austin took seriously. And that's what he communicated in the proffer to the agents, isn't it?
I'd have to look back and see what the proffer or the IR says. Again, those statements weren't made to me, they were made to agents with the TBI.
It's in the last paragraph. On the first page.
What I've got is agent Russ Winkler's IR here that says, according to Shane Austin, the topic of Holly Bobo came up here, Zach Adams answered twice. In regards to disposing of bodies, say you haven't got them so that they won't play. Shane Austin says that he also heard Zach Adams say, no body, no crime in connection with the Holly Bobo investigation. Zach Adams says this to a lot of different people. It should be heard the same comment from Mr. Adams, or from Zach Adams. That's what Mr. Winkler did.
Okay. And then towards the end of the IR, doesn't it also note that Shane Austin said he never believed that Zach Adams had actually killed Holly Bobo?
Agent Winkler notes on the second page, according to Shane Austin, he should have told this information earlier, but he was a little apprehensive. He grew up with Zach and went to the same church with him. He just never believed that Zach was saying what Zach was saying
written on the piece of paper and provided to the TBI. These are items that Shane Austin told the TBI he had heard Zach say. Is that correct? I mean, according to the report, these are things that he wrote down that he had heard Zach say.
He remembers it or doesn't remember it.
Sustained. Do you have a question?
Yes, Your Honor. And in fact, Shane Austin, during the proffer session, told the TBI that he had been with Zach Adams on the morning that Holly had disappeared. Isn't that accurate?
I'll have to look at the, that's, according to Agent Winkler's notes, or his report. That's what was said.
And also, he told the agent that he had gone into Parsons with Zach Adams and Dylan Adams to purchase Xanax bars during the proffer.
Again, according to Agent Winkler's notes, that's what was said.
And Austin denied that he had, in the proffer, that he had ever did Shane Austin disclose in the proffer that he had ever disposed of any evidence on behalf of Zach Adams?
Again, according to Agent Winkler's report, it says Shane Austin said that he did not help dispose of Holly Bobo's body. He has not ever gotten rid of any evidence, and he has never been asked to either.
Okay. And did Shane Austin, during the proffer, or deny to the TBI that Shane had anything to do with Holly's disappearance?
I'm sorry, I didn't understand the question.
During the proffer, did Shane Austin deny that he had anything to do with Holly's disappearance?
Again, and referring to the report, Agent Winkler's report, I mean, Agent Winkler's report said the notes in it saying that he did not help dispose of Holly Bobo's body, and he has not ever gotten rid of any evidence, and he has never been asked to do.
And does it mention that he denied having any personal knowledge of what happened to Holly Bobo?
Yeah, Agent Winkler notes on the first page, Shane Austin said that relevant to Holly Bobo investigation, he does not have any direct knowledge of anything to do with her disappearance or death. He claimed that everything he knows is based on what Zach Adams told him.
There's no further questions.
Mr. Evans, on March the 8th, 2014, 2 days after the proffer, you emailed Beth Boswell and said it is the position of my client that he was truthful, candid, forthcoming, and cooperative with the government in this matter. Right?
Yes, that's what the email says, that's what I said.
And the matter that you're referring to is the information you gave in the proffer. Right?
I was noting my client's position regarding the information in the property.
So that's yes.
I
in this matter.
Yes.
You're referring to the property. It's not a difficult question, Mr. Evans, you're a smart man. You're referring to the proper, were you not?
Yes.
There you go, not that hard. In addition to the information given in the proper, you are referring to 135 handwritten notes by Shane Austin, weren't you?
I was referring to exactly what it says, ma'am.
Right, and in fact, you thought your client was so truthful, forthcoming, cooperative, that's what you said, that you filed a civil court action to enforce the immunity agreement for Shane Austin, right?
Ma'am, I was an attorney.
I'm sorry, it's a real easy question. Yes, you filed a civil action, or no, I didn't file a civil action.
I did file a civil action. My thoughts regarding anything related to my client are privileged.
You filed a civil action, maybe privilege, but you put in here that your position, your client's position, that he was truthful, right?
Yes, I
But you wouldn't have filed a civil action with no legal basis, in your opinion, would you? Because that would be unethical.
No, I would never file anything that was not based in fact.
And so because you filed a civil action confirming, affirming Shane's veracity, that means you believed him with respect to Zach Adams and what he heard Zach Adams say. Because to do otherwise would have been you filing a civil action with no legal basis.
I can't answer that question.
Right. Done.
Yes, Your Honor.
Step in. Next witness.
Didn't have a basis, Your Honor.
Step. You want to be heard?
Yes, Your Honor.
I'm assuming you stated not wish to call witnesses.
We do not.
All right.
And so I'd like to see exhibit, was it 1, again, the proffer, it might be a So, Your Honor, the state's trying to make a point in this case that because Shane Austin came in, did a proffer, and said those things, that then that makes Shane Austin's position inconsistent with the trial theory in this case. And the state is clearly misrepresenting what happened at the proffer. What happened at the proffer was that Shane Austin went in and said, I heard Zach Adams say these things. He put it on a piece of paper. I heard Zach Adams say these things. He wrote these things on the paper. At no time did Shane Austin go into the proffer session and say, I know that Zach Adams killed Holly Bobo, or that anything of that nature. What he said is, look, I have no personal knowledge. I've heard Zach say these things. And Your Honor, that is not going to be inconsistent with the defense in this matter. In this matter, it's not inconsistent to say that Zach Adams may have had and said some crazy things. What the state is wanting everybody to overlook is the fact that Shane Austin was with Zach Adams that morning, that Shane Austin did not believe that Zach was telling the truth, that Zach Adams had said those things to multiple people, Your Honor. And that does not make a conflict in this matter. First of all, and I will just point to the law. You know, the state cites no law in this case saying that Mr. Evans cannot represent Zach Adams in this case. But in this case, and the law on attorney conflicts has changed in 2011. The whole law on professional conduct was wiped out, and there's no longer canons. Now it's the rules of professional conduct that are in play, and there's no longer an appearance of impropriety. It's that was removed completely. It's a true conflict in the case. And in this case, there's two types of conflict, and this is under the rules of professional conduct. There is either an actual conflict between two clients, two present clients. You can't represent one side and the other side in a divorce. You can't represent both parties in a divorce. And that's never going to happen. There's never going to be that kind of conflict between Zach Adams and Shane Austin, because Shane Austin is deceased and he can never be charged with a crime. The second type of conflict in this case is, or in the statute, in the rules, is that there is a conflict. You're representing a current client, and because of a representation of a former client, somebody you've represented in the past, because of something you know about that former client, it's going to restrict you on what you can do for the current client. And that is not an issue here either, because there's no tool in the attorney tool belt that Mr. Evans has that he cannot use for Zach Adams, because the harm in this case, because it was a criminal case in this matter, the harm in this case would be that Shane Austin would be charged with a crime, convicted of a crime, and that is never going to happen. So in this case, if it would be possible, and there would still be no conflict in this case, for Luke Evans to represent Zach Adams and go in and completely blame the whole thing on Shane Austin. He could go in there and said Shane did it and come up with a complete story about what happened. That would still not be a conflict with the past client, because regardless of what they would ever say, and this is just hypothetical, it could never result in charges against Shane Austin. And that's specifically what is in the law. I mean, that's what the law says. In addition, the theories are not inconsistent. The fact that Zach Adams may have said some crazy stuff in a bar does not make it more or less likely that Shane Austin would be charged in this crime. And it is not an inconsistent theory with what the trial theory would be. And so because there is no actual conflict in this case, then the court could look as to whether there's a potential conflict. Well, there's no potential conflict that could possibly arise in this case either, because Shane Austin can never potentially be charged with a crime in the future. It could not happen. And Luke Evans was representing him in a criminal matter. It's not like he was representing his estate or doing a will for him. He was representing him in a criminal interest. And that criminal interest has died when Shane Austin passed away. Then the law is also clear that the court used the wrong standard when determining whether or not to remove Luke Evans, because the court used the standard that was the appearance of impropriety that would erode people's faith in the judicial system. Well, there are 4 other attorneys in this case that could have possible conflicts. One, Mr. Maddox, and this is in the discovery, came in and did a proffer session with another witness who came in and said things about Zach Adams and Jason Autry. And he did that in 2014. In May of 2014, he met with TBI agents in this case, TBI agents that are here, did a proffer session, and they did a report on that. Paul Bruno, before engaging to represent Dylan Adams in this case, went to meet with Jason Autry in prison at Riverbend Prison at the request of Jason's mother to discuss possible representation. He met with him, he discussed things with him. But before he came on to represent Matt Maddox, he made sure that there was no conflict. They took appropriate action, discussed it with Jason Autry's attorneys. in this case, Jennifer Nickel was working for Matt Stowe.
Abject, Your Honor, never worked for Matt Stowe.
She was working on this case under the direction of Matt Stowe.
No, sir. Incorrect.
No.
She filed a, she was
Notice
on
of appearance pro
conference call.
tem.
Okay, well, she came in and was on conference calls and was working on this case while Matt Stowe was still the district attorney. Matt Stowe filed a notice that he had to get off the case because of a conflict. Jennifer Nichols was allowed to stay on the case. Under the code, usually when one person in a firm has a conflict and a district attorney's office is...
Do you know why Matt Stowe got off the case?
No.
It's essentially because he called the TBI a bunch of liars. Ms. Nichols did not call them that.
Well, it could be the appearance of impropriety, Your Honor, because he had a conflict and he got off and she stayed on.
Actually, I didn't say that, Your Honor. I got off the case.
Well, she's back on.
I got off the case and was not reappointed until after Matt Stowe was taken off the case.
That's correct. And I did not discuss that with her, but I got a call from her district attorney that said she will no longer be involved in this case, period.
Okay.
Once the conflict was resolved, I signed an order appointing her pro tem.
So she was working with Matt Stowe when Matt had a conflict, and that conflict was not imputed to her to work on the case later, even though it might have been. I mean, oftentimes a conflict is imputed to another attorney. Beth Boswell worked for two different agencies. She was the district attorney, or assistant district attorney in this case, and was also part-time special assistant United States attorney in this case. And she had two different roles. I mean, she
Why
represented...
don't we confine this to Zach Adams and Luke Evans?
So, Your Honor,
That's the conflict we're here to discuss.
yes, there's no conflict between them. And to be more clear as to what the law says, there have been other cases in the past where they looked at conflicts, and the courts have held that a conflict that is remote, that is, let me find the law here. There is a case called Burns. It's Burns v. State. And in that case, it was a death penalty case, and the post-conviction defender's office was appointed to represent Mr. Burns. At some point, the district attorney's office decided that they no longer wanted the post-conviction defender's office representing Mr. Burns. They filed a motion to have him recused, and the trial judge granted it, based on the fact that somebody in the post-conviction defender's office was a relative of the victim who had died in the case. And the Court of Criminal Appeals said, no, that was not enough of a reason, that there was not an actual conflict in that case. They evaluated that case based on the appearance of impropriety. And based on the appearance of impropriety, and then they went through other rationale as to what could be taken to assure that there wouldn't be a conflict, such as bringing the client into court, having the client say on the record that he waived the conflict, he understood it, and all of that could be done to ensure that the public would remain confident with the judicial system. But since the law was reworked, they've taken out that appearance of impropriety under the law. That now there's only a very, very narrow appearance of impropriety that is left in a comment number 9 to Rule 1.10 of the Rules of Professional Conduct. That cites a case, it was a Tennessee Supreme Court, in which an attorney was representing a couple in a boundary dispute. He left his firm and went to work for the firm that was representing the opposite side in the boundary dispute. The dispute was still going on. There were two current clients, and the Supreme Court found that the appearance of impropriety in that case was so strong, even if he promised not to tell any secrets, it still looked so bad that it eroded the public's faith in the system. But in that case, there were two current clients that were still in the same disputed matter with each other, and one of the clients had something to actually lose. I mean, one of the people was going to win at the expense of the other client. And there's a comment that still allows for an exception for appearance of impropriety if it's that narrow of a ruling. But in this case, Your Honor, the Board of Professional Responsibility found there is no conflict here. There's no actual conflict, and there cannot ever be.
What if they didn't have all the information?
Mr. Evans testified that he told them that he ran scenarios by, and one was, what if Mr. Adams actually came in and what if Shane Austin had actually implicated Zach Adams in the case, had said he did it, which that's not what we have here. Shane Austin said, I heard Zach say things, I never believed him, is what is in the record. And Mr. Austin ran a worse scenario than that by the Board of Professional Responsibility. And they said no conflict because Shane Austin can never be charged with a crime. And so I argue, and the other problem with this is the state has not filed any motion in writing. There's no motion, there was no oral motion as to what their objections were. There was nothing in writing.
They filed a response.
Well, I know, but they didn't file a motion. And they filed, I thought the response was to the recusal.
No, the response, all of it was in the same document.
Well, it's a response to the recusal, not to the court, not.
No, they covered all of it.
Okay. So.
I read it this morning.
In this matter, Your Honor, there's not a conflict. There can never be an actual conflict. There will never be a potential conflict. And so based on that, it was improper for the court to remove Mr. Evans. The court used the wrong standard to remove Mr. Evans, and therefore we ask that the court set aside that order and allow Mr. Evans back on the case.
Here from the state. Just get that right. You may.
Start again and go backwards.
You can go any way you want to go.
I'm dumbfounded that Ms. Thompson would say, there is not a conflict, there can never be a conflict, there, under any stretch, because I'm looking at her handwritten waiver where she got Zach Adams to sign saying the exact opposite. The exact opposite. So for her to stand before the court now and tell you that under no conceivable scenario could there ever be a conflict leads me to believe that they, the defense, really are trying to set up a situation where in the event of a conviction, in the event that Zach Adams is sentenced to death, that they have a built-in successful post-conviction relief petition and or federal habeas. Because why else would you say that? Why else would you sit here in court and say that we have consistent defenses when they are so clearly inconsistent? If you're not trying to set it straight. And as far as bringing Mr. Maddox into it, Mr. Maddox had a proffer with somebody that wasn't a suspect. And he's free to stand up and help me out.
I'm not interested in Maddox. I'm not interested in whoever else she said had it. We're here, as I said earlier, concerning defendant Zach Adams and Luke Evans. Is there a conflict is what the subject is.
Trying to stay in course, Your Honor, it's clear that there is. They cannot know how this trial is going to play out. And there are so many scenarios where the exact things that they are saying do not present a conflict, simply do. We have TBI agents who were witnesses to things said by Shane.
There have been statements made by Mr. Scholl on the record today about representations he was made to Your Honor about his client situation. I'm not going to get into that now. But there is a conflict. If Your Honor wants us to spell out in more detail the situation of other defendants, we will. It was my hope to avoid doing that at this point in time. The representations made by Shane Lawson, things he overheard, or things that Zach Adams told, regarding murder, rape, kidnapping of Holly Bobo. We have other proof confirming those statements. We absolutely put on the record what was said before, and that's what we're asking Mr. Evans, that you confirm disqualification of Mr. Evans from this case and allow us to proceed with attorneys that don't have that conflict.
Right, thank you.
I would like to address the one issue about the waiver of conflict, Your Honor. If you do a waiver, then they say, and especially a waiver of something potential, you just say, there might be something in the future and I waive it. That certainly is not indicative at all that I was trying to be sneaky or tricky. I mean, a waiver just says whatever's there, I give it up. And as an officer of the court, I am absolutely not trying to do any kind of tricky things. I'm trying to take this man to a trial and do the very best job I can for him. And I believe that at this point, having a third attorney is absolutely essential. The state has 4. And Mr. Evans was an excellent choice because he knew facts about the case and he was ready to get to work on it.
Let me ask you something concerning ex parte motions under Rule 13. I have met with all attorneys in this case at various locations for ex parte motions concerning services. I've met with you or Mr. Simmons in 4 different counties and in the city of Nashville to accommodate. Do you recall a conversation where you mentioned to the court that you might ask for an additional attorney, essentially that the state had 4 and you felt like it? You felt like that it merited?
Yes, sir.
You recall my response that that's in violation of court rule, it can't be done, and you said I might want to build a record on that sometime.
Yes, Your Honor.
But yet you proceeded with an ex parte motion as opposed to a motion for extension of Rule 13 to add a third attorney.
I guess all funding motions under Rule 13 are ex parte, as I understand them.
The appointment of attorney might not necessarily be.
Well, the funds to pay for an attorney would be, if we're.
But the state had no opportunity to raise the conflict issue because of the way it was presented, correct?
That's correct, Your Honor.
All right. Take about a 5-minute recess and then we'll have a ruling.
All rise. Get back to our seats, please. All rise.
Mr. Simmons is French with us.
He's running back. I know that people run to the restroom. I didn't know they ran back. All right, be seated. Concerning the court's ruling, in retrospect, which they say hindsight is 20/20, the appointment of Mr. Evans should never have taken place in an ex parte motion. Those are for services and things like that to provide indigent defendant adequate representation, such as, and I'm not referring to anything in this case, I'm just saying in general, mitigation specialist, investigators, there's any number of things. It should have occurred to me that I've never seen an attorney put on board through an ex parte motion. The first time I realized that that was the improper vehicle was when I got the telephone conversation of less than 2 minutes. She said, I have concerns. And it occurred to me at that time, they had not been able to express concerns that the court might have been very interested in. That's why this should have been taken up in open court, where they argue that, yes, Rule 13 requires 2 death penalty certified attorneys and does not provide for a third attorney. Mea culpa. I shouldn't have done it that way. But once I realized that what the conflict truly was in this case, I didn't let either side go into any discussion during that telephone conference. And the words that I used were not appearance of impropriety by Miss Aaron, by her notes that were read earlier. It was appearance of conflict. I am absolutely satisfied that there is a conflict in this case and that there is a distinct likelihood of additional conflicts developing throughout this case, and particularly in the sentencing phase, where the rules are different. There might be hearsay. I think Mr. Evans would be placed in an absolute conflict of interest, having received information from his now deceased client that might be in conflict with what Mr. Adams might or might not place evidence concerning. I honestly think that probably there's no one in this courtroom, with the possible exception of Ms. Thompson, that does not see the conflict in this case. It's overwhelming. If we were to use the medical scale of 1 to 10, where they ask you pain, I would say conflict is at 10 on this case. That's how strong it is, and that's how strong the court feels. It's not proper for Mr. Evans to serve on this particular case. The court confirms its earlier disqualification. I will prepare an order consistent with this. Also, I want to say that concerning the court's recusal, under 10B 2.04, the filing of a petition for recusal appeal does not automatically stay the trial court proceeding. However, either the trial court or the appellate court may grant a stay on motion of a party or on the court's own initiative pending the appellate court's determination of appeal. That stay is hereby on the court's own initiative, granted in this case concerning the recusal motion. All right, anything further?
I'm sorry. I would like permission to appeal an interlocutory appeal on the disqualification of Mr.
Denied. You may seek an extraordinary appeal if the Court of Criminal Appeals wishes to grant it. I don't see this as an issue. Yes, sir.
Your Honor, there have been a number of Rule 17 subpoenas, and I would ask that anyone here in response to a subpoena with records in the arguments.
Amen to that. I don't know how many I've signed, okay? But I would say probably 25 at least. And once again, I've met, I can't think of his name, with your investigator a multitude of times. I've tried everything I can do to try to help the parties expedite this, including scheduling the ex parte motions, meeting your investigator for purposes of issuing subpoenas, the ones that can't be issued by the clerk.
Correct.
But what I'm saying is, I've tried to accommodate so that we can keep a reasonable time scale on this. And as one of the attorneys said at the outset, it might have been her, I gave everybody in this case my cell phone number and said, to avoid any problems whatsoever, scheduling or otherwise, you're free to call that number. Okay?
Yes, Your Honor, if there's anyone in the courtroom that is here in response to a subpoena.
Anybody here that's been served a subpoena to provide certain records?
I did, sir.
Okay.
I think we got it all. Thank you.
All right.
And then, in response to that, Your Honor, reciprocal discovery motion has been filed, and we've never gotten anything, so we sure would like to keep that as a moving forward with Mr. Adams, Zach Adams in particular, since he's going to trial in 3 months.
Right. I don't want to do it right now. I want to keep the thing on fire. All right. I did not stay. I said on the front end I would not stay it. You know, the reason that the trial court doesn't stay proceedings, any case that I have set, somebody can file a motion to recuse 30 days prior to trial, and if it is stayed, your trial date is busted. So I specifically am not staying anything in this case, okay? If I misspoke or misunderstood, I want parties to understand that. All rise. Grab that. Need from the first motion and ruling, I need that transcribed where we can attach that to an order, okay?
Your Honor, I believe there was another court date that was potentially set.
Right. March 1.
Judge, may I ask if behalf of Mr. Autry, we do not participate in that report date. We are taking a different route. We are not set to trial in April, and we will have nothing to do with report to the court.
Be excused.
Thank you.
I've excused both defendants from being present today because we weren't taking anything up regarding that.
Can counsel for both defendants be excused from that?
If they wish to, yes.
And Dylan Adams here on March 1.
We'll have to let you know. We'll let you know.
Court's adjourned.
To any other potential witness in this case, or any kind of incident reports or alleged gang affiliation could be relevant to any other witness in the case. The commissary trust account records, visitation records, including visits from law enforcement, or records regarding transportation away from the facility could possibly have any kind of relevance to any other issue or any other witness that potentially might provide testimony. To any other potential witness in this case, or any kind of incident reports or alleged gang affiliation could be relevant to any other witness in the case. The commissary trust account records, visitation records, including visits from law enforcement, or records regarding transportation away from the facility could possibly have any kind of relevance to any other issue or any other witness that potentially might provide testimony in this case. With regard to the phone conversations, there's, without knowing who all may have been on the other side of a phone call in this case, I don't know if there's any other potential witnesses that are going to give testimony that are on the calls. But in particular, I wanted to address any particular calls that might have been made between Mr. Adams and his counsel. We don't believe that any kind of attorney-client privilege has been waived whenever there's a phone call between Mr. Adams and his counsel. I'm not certain as to what, when a phone call is made, if there's any type of disclaimer given at the beginning of the phone call. I know some jails give a disclaimer saying these calls are being recorded or things like that. But even if that were the case, even if that were the case, because an inmate has, either the choice of visiting in person with his counsel, or if he ever wants to talk on the phone, it's not like the inmate has a choice of phones to use or devices to use that would not be recorded. They're somewhat forced to use whatever's available to them in order to make contact with their counsel. And I don't think that that's any kind of a voluntary waiver of attorney-client privilege. So if the court were to rule that the phone calls can be subpoenaed and reviewed by the defense by the Zach Adams defense attorneys, I think the court should exclude any review of any phone call made between John Dylan Adams and his counsel, because I don't think there's been any kind of a voluntary knowing waiver of attorney-client privilege under any condition. And I think those should be redacted from any kind of disclosure. But kind of the bottom line to the whole motion is, I don't see how these records become relevant in this particular case if Mr. John Dylan Adams is not going to give testimony in the case on behalf of either side.
Jim Simmons, Your Honor. As you may recall, when this issue's motion was first filed, we agreed not to review any of the records until it is ruled upon. The important part of this decision, I believe, is we do not know whether Dylan Adams is going to be a witness or not a witness. That's been suggested he would not be a witness, but that hasn't been confirmed, so he still may be a witness in this case. Broadly hinted. I don't think that's quite different from. But regarding the medical records, incident report, all of that could become very relevant, either if Mr. Dillon becomes a witness or in going through that as to the information that may lead to relevant evidence. It's not simply subpoenaing relevant evidence. It could be under discovery information that then would lead to relevant evidence. And as a practical matter, Your Honor, most of these documents we received from the state. That egg has already been out of the basket. We're talking about unscrambling the egg at this point, because many of the documents were supplied through the state, which means they've already been provided through the discovery process. As far as the telephone records, I think it's clear that if he makes a phone call and there's a disclaimer saying this call is being recorded, it is subject to being reviewed, there is no attorney-client privilege. And the Eighth Circuit case of Hatcher is squarely on point, dealing with a co-defendant whose records were not provided upon request, and the Eighth Circuit found that was error. Now, in reversing it, the two things occurred. One was the court was very critical, because in order to determine whether they're relevant, in fact, this court's got to review them. You can't say it's not relevant unless you look at the records. You can't say it's attorney-client unless you review the records. So I think on its surface, there's no privilege, and certainly the documents we have requested are either relevant or they could lead to relevant information, and the information has already been provided through the state. So, Your Honor, we'd ask that the motion be denied.
I did want to say one thing, just in full candor with the court. Okay. Well, I just wanted to disclose I had listened to some of the tapes before they filed.
Your Honor, I would like to, those documents that we already have that have been produced, we'd like to file them under seal for the record.
All right, but you'll be given, in their motion, quash, you'll be given items 4, 5, 6.
Thank you, Your Honor.
That takes care of John Dillon's, everything he's got.
Yes, Your Honor.
And let's take that 5 minutes, that way we can get them transported, and then I'll take up the rest of the Zach Adams. All right, other potential motions, the state has filed some notices, one under 609 for possible convictions of the defendant for purposes of impeachment. It would be premature at this time to rule upon that. I've looked at it, and in all candor, the majority of what they have filed, the court's not prone to be allowed in for purposes of impeachment. There are some felonies that are less than 10 years of age that in all likelihood the court would let in with appropriate instruction. State's got a 404B motion as well as 12D. And it would be premature at this time because I don't know what the proof will actually show. So I cannot weigh those matters and determine what might or might not be admissible in the trial of this cause. So that will be reserved to be ruled upon at trial. As soon as I can give you an inclination, I think it's fair to both sides to let them know kind of what I'm thinking, and then be open to discussion on either side. The state supplemented their expert disclosure. I've read through that. There are 2 forensic anthropologists that they have given a full curriculum vitae on, and the court's looked at that, and I anticipate that they will be qualified and allowed to give expert testimony in this case based upon that. The state has filed certain motions in limine, and likewise, they are premature at this particular time, subject to them being made relevant at the trial of the cause concerning testimony of various people. And court will not be allowing opinion evidence from the people that they have listed on that. Opinions can only be expressed by experts, and there wasn't anything that indicated that they were being offered as expert witnesses. So we're still a little bit premature on that as well. State has also given notice of immunity agreements and listed the people that that they have made immunity agreements with. There's some 5 in number, but you folks have that, and I would assume actually have copies of the agreements. You don't know what they do? Okay, that will be made available. It's appropriate to you to be able to consider that in the defense of your client. What else do we have today? Yes. She just reminded me this. This goes without saying. I've got professionals on board. Prior to seeking to introduce anything, 404, 609, we'll have bench conferences. I've also discussed with the press, the press that will be pooling to the others, that bench conferences, no mic. During breaks, no mic. I told them I don't want it being broadcast on TV how bad my golf game is right now because we're on recess. So it will be dead mics during recesses, also dead mics during any bench conference. Bench conferences should be reserved only critical or necessary because it's very difficult to get up here, and I don't want to risk the jury overhearing something. It's not a long distance away, but at the same time, I don't like marching them in and out a multitude of times. So that should be reserved basically just critical situations. Is there anything else? And as I said, we're slightly over 2 weeks from trial.
Your Honor, at this point, I foresee us, or I guess at this time, I'd like to make an oral motion for a continuance. I recognize the court's been very clear that it intends to try this case when it's already been set, but there is a gun that the state has now, I guess, after 6 years, they've dug up a gun somewhere that it's my understanding they're going to say the gun is going to be.
And my understanding is that as soon as they got that, you were forwarded this information.
Well, we were forwarded a picture of the gun and told what the caliber was. We don't have any reports on it. We haven't been able to inspect it. We are anticipating that we're going to want to try to get an expert after we get, if they're having the gun tested at a lab, we anticipate that we're going to want to try to get an expert. We've contacted, or we've gotten some names of some experts that we're planning to try to contact. But at this point, we don't have the gun and we haven't had an opportunity to inspect it. And so I think because that's going to be such an important factor now in this case, it's my understanding they've only had it since about Memorial Day. So, but all we've received are 3 pictures of the gun and an email telling us what the caliber is. We don't know what the serial number is or what the make and model of the gun is, and I think all that's going to be very important.
They'll furnish that information. You can move to exclude if you feel it's appropriate. Motion to continue is overruled. Yes. I saw the picture. Somebody, I think she sent them to me, or you did, or someone.
I had actually notified the before that.
Okay. So motion continues overruled. As I said, I want to be available essentially between now and trial to keep problems from arising. I will tell you, I can make the following dates available next week. Monday afternoon, probably 2 o'clock or after. I've got a jury trial in Benton on Tuesday, which I will continue in deference to this case if there's something that we need to. I want to avoid any disputes. So I'm saying I can take up discovery matters, whatever we need to do. Not available next Wednesday. I can be available next Thursday or Friday. The following week, I can be available July 3rd, and then after that, we're a little close to trial. Potentially, I could be available the 5th. That's the day before we finish our jury selection. I will let the press know there will be no cameras on the 6th. That's pursuant to the rule. We'll be totally involved in jury selection at that time, addressing the issues that have not already been addressed during the individual voir dire of these people. They'll be coming back in on the 6th. I anticipate that when we get the jury selected on that day, that I will excuse them with admonitions to, once again, not view or listen to any news reports or anything else. I will swear the officers that will be guarding the jury that day so that they can report to Pickwick Landing State Park Inn on Monday so that we can start the trial. They'll be sequestered from that point. We'll start the trial promptly at 9:00 a.m. on July 10th till its conclusion. I anticipate running from 9:00 in the morning, and I could start a lot earlier, but the jury's sequestered. It's impossible to get it much before that. Be running till probably 5 or 5:30 in the evening. Once again, I don't mind going later, and if there's something that we need to take up outside the presence of the jury, perhaps we can do it, but I don't want to mistreat the citizens that are sequestered. I anticipate running 5.5 days a week, Monday through Saturday around lunch. And then I think to push it beyond that, it's going to be grueling like it is, not only for us, but for the jurors. So they'll be given Saturday afternoon and Sunday. Sheriff will do what he can to make it as pleasant as it can be under unpleasant circumstances. So we'll look at that. I also will tell you, and I'll take care of it, okay? Hey, I've got this, okay? Lost my train of thought, which becomes more frequent. Oh, yeah, thank you. Thank you, both sides. Curry favor with the court. They'll probably, might even get them to open the movie theater. We won't be showing my cousin Benny to them or anything that's related to the courtroom. I don't know, that might be something good to show to them, but they will host them. Oh, I know what I was going to say. Got a call from one of our jurors who is pre-qualified that presents a reasonably good hardship reason. I'm not going to discuss the name here, but I will make the parties aware of that. As a matter of fact, the gentleman I thought would be an excellent juror, but his employment probably would suffer hardship. So I'll let the parties know further about that. Also, I did let the parties know we had one of our prospective jurors that moved out of the state. She has been released. I thought she would make an excellent juror, but she has moved to on the coast, maybe Florida, I think. But I let the parties know before I released them. In other words, I'm not going to do anything at this point without the full knowledge of the parties. All right. Anything further from the state? I think it's appropriate. There doesn't need to be any mention unless I determine that someone's going to give testimony or not give testimony. And there's some fairly, I think it was filed under seal because there's some fairly sensitive matters there. And I earlier have discussed that I don't want any disclosure of these sensitive matters without permission of the court. All right, anything else from the state? Anything further?
I had some questions about the arrangement of the courtroom. I don't know if the court wants us to take that up now or just in private.
Just general?
Well, one of it is, my team has a lot of laptops and computers. We might even be bringing a big computer. I would prefer, is there any way we could just tilt this at a right angle so people in the gallery cannot?
Let me do this. Let's recess. This isn't critical, so your client doesn't have to be here. Let's let the press get gone, and we'll have informal discussions. I want the sheriff to remain with me. He'll be here. You'll find that the sheriff, as well as the clerk's office, is very, very accommodating. So we'll do what we can to accommodate, okay? All right, anything else? All right, let's recess for 15 minutes and then we'll address this informally.
He took her. He raped her. He killed her. He discarded her. He covered it up. He bragged about it. And he almost got away with it. He took her. He raped her. He killed her. He discarded her. He covered it up. He bragged about it. And he almost got away with it. He bragged about it. Zach Adams. He bragged about it. I couldn't have picked a prettier bitch. It was fun. The world may never know what happened to Holly Bobo. I couldn't have picked a prettier bitch. It was fun. The world may never know what happened to Holly Bobo. Holly Bobo, 20 years old, nursing school, working hard and doing good. She had a boyfriend that she loved, Drew Scott. She lived with her mom, Karen, her father, Damon, and her brother, Clay. Dana wakes up every morning real early to go to work. Karen wakes up early to go teach school. She's a school teacher. She's known in the community as Miss Karen. Clint, 5 years older than Holly,
25 at the time. Went to school and had a job. That was the family. And they lived in a little house that Dana built with his dad. House was on a small street named Swan Johnson, off another smaller street, Michael Town Road, outside of Parsons in Decatur County. It's where Holly and Clint grew up. It's where they were still living. It's where they were supposed to be safe. It was their home. I couldn't have picked a prettier bitch. It was fun. The world may never know what happened to Holly Bobo. Zach Adams, older than Holly, real different. Meth and morphine and the dark, dark things that go along with it. Meth and morphine and the dark, dark things that went along with it. That was his life. His friends, Jason Autry, older than Zach. Zach looked up to him. They're just like Zach. Meth and morphine and the dark, dark things that went along with it. Shane Austin, same. Meth went along with it. And the dark, dark things that went along with it. And his brother, John Adams, who lived with his grandparents right across the way from the house of Zachary, a younger brother who he treated badly, but the same. Meth, morphine, and the dark, dark things that went along. As dark as this life was, in the immediate days, April 11th, April 12th of 2011, it was even darker for Zach Adams. Meth and morphine had become more and more and more. His girlfriend, he'd been with for some time, trying to leave him, trying to break up, trying to get away. On top of the meth and morphine, now threats and rage. Zach Adams in the days right before. I couldn't have picked a prettier bitch. It was fun. The world may never know what happened to Holly Bobo. April 13th, 2011. April 13th, 2011. That's the day on Holly's headstone. That's the day that she was taken. She woke up real early that morning, Wednesday morning, middle of the week, real early, to study for a test and to prepare note cards that she had to turn in that morning. It was a test that she wanted to do real good. And she was up real early in her little house in Swan Johnson with her family to study for it and to do her work. Dana up early to go to work. He sees her light on, the door shut. She's studying. He sees her light on, and he talks to her through the door. Her dad didn't see her. The door was shut. He'll never talk to her again. Karen Mona wakes up to get ready for school, where she teaches. She helps Holly pack a lunch, fixes a little breakfast. She sees her and she gets to talk. She gets to help her. She'll never see her daughter again. Holly Bobo. This is the one day of the week that he doesn't work or go to school. He's at home, in the bed, asleep. True Style, the boyfriend that she loved. That morning he had to go to work too, but before, he was going hunting with his dad and his dad's friends. He was texting Holly. He knew she was going back and forth, boyfriend, girlfriend. About 7:42 a.m. 7:42 a.m. The last text that Holly sends. You never hear from her again. Minutes after 7:42 a.m. Wednesday morning, April 13th, 2011, Holly walked out of the back carport door to that little house, her home, where her car was, to leave, to go to school, to turn in these note cards and take a test. And that's when it happened. Neighbor hears a scream and a call for help. Clint wakes up and hears voices in the garage. A male voice, female. He gets the flash of a man in camouflage walking with his sister into the woods. And there she goes forever. Gone. Only trace of her, the only evidence of her for anyone, drops of blood right there at the back carport door leading to her car. Drops of her blood right there. Right there at the back car. Gone. Just gone. For 3.5 years. About the same amount of time you send your son and your daughter on college. For 3.5 years. September 7th, 2014. Her skull, teeth, some ribs, pop, found in the woods, off interstate, near cell phone tower, between two sawmills, just 4 or 5 miles from Zach Adams' house. Those 3.5 years didn't pass quick. There was eternity on top of eternity. For Karen and for Dana and for Claire, for her family, for the community that volunteered and searched and searched and searched. For the men and the women in law enforcement who searched and searched and searched and followed lead after lead after lead after lead. They searched every outhouse, every well, every place they could. Hope against all hope that they could bring her back to Dana and to Karen. That maybe they could bring her back alive. 3.5 years. During the course of chasing lead after lead after lead, they had an idea. Not a bad idea. They had an idea. Let's check the local sex offenders. College is beautiful. Let's check the local sex offenders. The law enforcement did, and they concentrated on one man, a man by the name of Terry Britt. A bad man with a history, man who lived in the same general area. And they ripped into his life. They ripped into his life. Talked to all his friends, all his family, his wife, him. Searched his house over and over. Followed him, watched him, tapped his telephones, tapped his house. They ripped into his life. But every time, absolutely nothing. Absolutely nothing. And so what did the men and women of law enforcement do then? Did they give up? They spent 1.5 years ripping into this man's life and they got nothing. There was nothing there. Nothing to it. Did they give up? Did they just give up? No. They rolled their sleeves up. They put their head down. They retraced their steps. They circled back. Early leads in the investigation. Zach Adams, Jason Autry, Shane Austin. Early leads from the first days of the investigation. Zach Adams, Jason Autry, Shane Austin. Mysterious scratches. Mysterious scratches on Zach and Shane. Suspicious behavior. Alibis that didn't check out at all. At all. Her girlfriend, Zach's girlfriend, the one that was trying to leave, who saw things, who heard things, and who within 2 days of this bad thing happening was certain that her boyfriend, Zachary Adams, had done it. They rolled up their sleeves. They rolled up their sleeves and they went into the dark world of meth and morphine and Zach Adams' friends. Interview after interview with people that we hope, we wish we'd never meet. And from them, they heard about Zach Adams. They heard about what he did, and they heard about what he said. I'll do you like I did Holly Bobo. I'll lie you in a hole next to her. You have to kill a bitch to get a $2 million bond. I did it. They talked to his friends, and they heard his words. Those were his words. They looked at these alibis, Zach and Jason, and they were lies. After years, after essays, after a desperate search, they had it. They had Zach Adams, his own words, his own lies. They had his friends. They had it. They had him and Jason Autry, and Shane Austin, and John Dylan Adams. They had it. And even then they didn't stop. Because it wasn't enough to know who did this. It wasn't enough to know who did this. They rolled their sleeves up a little higher. They put their heads down a little bit more. And they said, we're going to get some answers as to what exactly happened to this girl. What they did her. So if you want to find out about a bad thing, eventually, sooner or later, you got to go talk to a bad man. And after years of denying, after years of lying, they went to Jason Autry. And told him what happened to that girl. He describes phone calls he had with Zach Adams the morning of April 13th, 2011. He describes how he wanted morphine and Zach wanted help. He needed Jason's help with something. This man that Zach looked up to, old. Jason came to him, to Shane's trailer, Shane Austin, Zach's friend. When Jason got there, there's Shane, Zach, and Dylan. Something crazy's happening. Everybody's acting crazy. Shane's yelling. Zach's dark. Very dark. And Jason sees a blanket in the bed of Zach's truck. There's a body blanket. He sees the three of them, Zach, Shane, and Dylan, and a body in a blanket in the back of Zach's truck. Within, give or take, an hour and 15 minutes of Holly Bobo being taken. Zach tells Jason, I need your help. I've got to get rid of her. Jason's a bad man. Jason's who he looks up to. Jason's a leader. At that point forward that morning, Jason will tell you he was in charge. We're going to take her to the river, to a place that Zach knew very well, under the I-40 bridge, the Tennessee River, near Birdsong. And we're going to gut her so she doesn't float off, and we're going to put her in the river. Jason's a bad man. At that point that morning, he was in charge. Him and Zach load into the truck, and they drive to that place. We pick up the blanket from the back of the truck with her in it, getting it out of the truck. They put it on the ground on some rocks. And when they do, she makes a sound. She moves. She's still alive. It's a time for grace. She's still alive. Now, Zach walks to the truck. He goes inside, and he comes out with a gun. He walks toward her. He's wrapped up in a blanket. Jason says, whoa. Whoa. Not to stop him. Not to stop him. Whoa. I need you to look out, make sure nobody's down here. It's a bad, bad man. He walks fast. Probably about 20, 30 yards. Gotta go about 20 or 30 yards so you can look down and see a long gravel road that comes this way, so you know whether or not somebody's coming or not coming. He looks down and sees nothing. He turns around. He starts back. He gives Zach the nod. Is it time for grace? No. Zach feels down under the blanket, finds her head, and fires a shot into her head and kills her. There'd be no grace. Jason and Zach would talk on the way back. Their own words. How did this bitch end up in the back of your truck? Zach will tell him. We took her. There's shame. We took her. Shot her up with drugs. We raped her. We thought we would kill her. And now Zach had to kill her. So now after years of searching, after years of leads and false leads, after years of going into dark places and talking to dark people, not only did they know who, but they know what happened to that girl. For your bitch, it was fun. And you'll never know what happened to Holly Bobo. You can understand that tone. You can understand that the world will never know what happened to Holly Bobo. Because it had years. It had years to destroy evidence, to scatter evidence, to get rid of crime scenes, to build lies on lies. He had a 1.5 years, 2 year head start. You can understand why he was so confident that he'd never get caught. No DNA, didn't leave fingerprints behind. Crime scenes long gone. For years, the police were looking at the wrong person. You can understand why you can understand what he was saying. He thought he had gotten away with it. But we didn't give up. took her. He raped her. He killed her. He discarded her. He covered it up. He bragged about it. And he almost got away with it, but he didn't. Because we're here now. Crime scene's long gone. No DNA. No fingerprints. A body that decomposed in the woods for years. Oh yeah, and a gun too. A gun. You see, when investigators talk to a bad man like Jason Autry, it doesn't stop there. They check in to the things he says. They check what he's saying against facts and witnesses. And over, the facts will cooperate. What he said happened. And he told him something else too. He told him about the gun that was used to kill him. He told him who they sold it to. And the investigators hunted people down. And over 6 years after this thing happened, the investigators literally dug and dug and dug by a little stream, over the creek, by a little road in Holiday, Tennessee, 2 or 3 miles from Zach Adams' house, and found the buried gun that had been there for years and years, that Zach Adams had used to kill Holly Bobo. Yeah, crime scenes have been destroyed. Yeah, he had years to run. Yeah, he scattered evidence, he destroyed evidence, but we're here now. We're here now. And this week, for these weeks, we're serious men, and we're serious women to do serious things. We can't undo and we can't stop what happened to her, what happened to her. But here this week, we can do what's serious, what is hard, and what is right.
Okay, we're going to go ahead and call today and the stream. Ada and the stream will be back tomorrow. We hope everything is going fine for her at the hospital with her friend. And we hope to see you all tomorrow. You all have a good night. Bye.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.